Laverne, you're muted. We cannot hear you.
Sorry, okay. Aloha, Chair and members of the committee. Laverne Moore speaking on behalf of Osa Tui, President of the Hawaii State Association. The Hawaii State Association believes that in order to better promote the study of Hawaiian culture, history, language in public schools, as required by the state constitution, there must be some representation of Hawaiian community on the Board of Education. The HST is in agreement that at least one member be an at-large member of the Board of Education, be a Hawaiian immersion expert selected from a list of nominees selected by Aha Kauleo Kai Apuni, Hawaii. This is ensuring that an expert on Hawaiian immersion is advocating towards the expanding and promoting Hawaiian immersion in our public schools, including our public charter schools. The Hawaii Teachers Association asks your committee to support this bill to move forward on this promise. Mahalo for the opportunity to testify.
Thank you. And sorry, I forgot to remind all the testifiers that there is a 2-minute limit out of respect for the other testifiers. And if you could turn your video off, please, when you're not testifying, we would appreciate it. Next up, we have Kanayo Kana in support.
Aloha Chair Nakashima, Vice Chair Matayoshi, and committee members. Ovao o Alana Farden, I'm representing Kanayo Kana, who is here in full and strong support of HB 1986 HD1 that will require one Board of Education member to be an expert in Hawaiian immersion. Kanayo Kana is a network which includes membership of the Department of Ed, Hawaiian Language Immersion Program sites, all 17 Hawaiian-focused charter schools, and over 50 other Hawaiian education organizations, including the Native Hawaiian Education Council, in strong support of this measure that will ensure we have a Board of Education member who has subject matter expertise in the DOE that has become the state of Hawaii's sole vehicle to provide for the revitalization of Hawaiian language for K-12 learners in public education. Since Native Hawaiians do not control their own educational system, the trust relationship that Native Hawaiians have with the state of Hawaii in regards to education is accorded to the Hawaii Board of Education. And as such, proper representation to the Board of Education with an expert in Hawaiian immersion should be codified into law. Mahalo for this opportunity to provide testimony. We stand by our written testimony that was submitted and received on time and implore the committee to support HB 1986 HD1. Mahalo.
Thank you. Next up, we have the Aloha Aina Legal Group in support.
Aloha, Chair Nakashima, Vice Chair Matayoshi, and members of the House Committee on Judiciary and Hawaiian Affairs. I'm Shardy Freitas, one of the partners of Aloha Aina Legal Group, and we stand in strong support of HB 1986 and also in solidarity with Aha Kauleo. In addition to standing on our written testimony, I also wanted to add as a makua for 5 of my keiki who we anticipate, if they're not currently in the Kaiapuni system, that they will join when they are of age, as we have raised our kids from birth, Maku'olelo Hawaii. You know, what this models for them to have a dedicated representative on the Board of Education with this expertise. And, you know, there are many ways to achieve equity, and having this type of representation is one of those ways to achieve equity. Other than that, I also wanted to bring forth the Olala no Eo Nanai Kikumu, which translates to mean looking to the source, and having that source of knowledge, source of ike, source of information as part of the Board of Education is critical. And it's not new that this type of relationship, that type of expertise has been provided to the BOE. The BOE themselves have already acknowledged that they have benefited from having that type of expertise. Mahalo for the opportunity to testify, and I urge you to pass this bill. Mahalo.
Thank you. And just a reminder, please turn off your videos if you are not actively testifying. Thank you. Next up, we have Naleo Ko'o Maui in support. Nope, not here. Kanayo Kana Network in support.
Vice Chair Matayoshi, we had provided our testimony earlier. Mahalo.
Okay, sorry, I've got you on here twice for some reason. We have members, we have a number of individuals testifying in or submitting written testimony in support as well. I'd estimate about 40 of them. Only 2 are scheduled to testify though. First up, we have Brian Faria in support.
Aloha, Obana Okahea Faria. I made a mistake when I submitted mine, so my name wasn't on to testify in person. So Kyoki's giving me his slot.
That's fine.
Aloha mai, Kako, Chair Nakashima and Vice Chair Matayoshi and members. I am Kahea Faria. I stand by my written testimony in strong support of this bill. And just wanted to share that what this bill asks for, there is precedent for a Hawaiian expert on a state board or commission, such as I believe, the BLNR, Board of Land and Natural Resources, has a Hawaiian expert, and so does the Water Commission. So I just wanted to share that there is precedence for what we're asking for, what this bill is asking for. Other than that, mahalo nui for this time to provide testimony.
Okay, thank you. And lastly, we have Kanani Nohea Makaimoku in support.
Ai e ka luna ho'omalu Nakashima, e ka hope luna ho'omalu Matayoshi, a me ke komike ho'okolokolo a me kuleana Hawaii. Aloha ʻoukou. My name is Kananino Makaimoku, Kananino he Makaimoku, and I am a graduate, a parent, a former classroom teacher, and currently a teacher trainer for Kumukaiapuni. I also represent the Aha Kauleo as the vice chair. The Aha Kauleo represents 27 Kaiapuni Hawaiian immersion schools, community organizations, and university partners, and advises the Office of Hawaiian Education. I, as well as the Aha Kauleo, is in strong support of HB 1986. We would like to reiterate the comment made by the BOE in their last testimony at the last hearing that said there is clear value to having Hawaiian immersion experts serving on the board. Kaiapuni schools have continuously expanded since its founding. The program could not have grown without the foresight of our legislative leaders and our Board of Education members to make fundamental policy changes and advancing forward policies, such as recognizing Hawaiian as an official language in 1978, lifting the 90-year ban on Hawaiian language instruction in public and private schools, and establishing BOE policies 105.7 and 105.8. Passage of this bill will be another significant cornerstone in the history of public education. I stand by my written testimony, and I am available to answer questions. Mahalo for this opportunity to testify.
Thank you, members. That's all the testifiers we have here today. Any questions?
Chair.
Rep. Nakamura. Rep. Nakamura, you're muted.
Thank you, Chair. I wanted to ask a question of Aha Kauleo. My question is that the Board of Education in their testimony are concerned that Aha Kauleo Kaiapuni Hawaii does not appear to be an entity of the state. So I just wanted to clarify, is the Statewide Council a nonprofit organization?
Yes, nonprofit organization.
A 501c3 organization?
Actually, that I do not know. I can find out the answer to that and get back to you.
Okay. Okay. I think that might be something to just to clarify, since that seems to be their major concern about naming you as the entity to come up with the list of names. So I think it'd be good just to be able to address that issue. Thank you.
Thank you.
Thank you. Rep. Ward.
Thank you, Chair. Laverne Moore, the longest serving DOE teacher in the state of Hawaii. Are you there, Laverne? I want to see your face. And by the way, the chair didn't say turn off your face. It's only that the bandwidth is better when your face is not being shown. mean, we'd like to see your faces, but just so you know what
When you are
look like.
testifying, please turn your video on.
Yes,
record us
exactly. Because sometimes we can't hear you if the video is on, et cetera. Laverne, question. What should we expect with the passage of this and the increase of a Hawaiian expert on the board? Give me some implied betterment that should come out of this. And you are
Laverne,
muted.
you're
I see your
muted.
face, but only your moving lips.
Okay, speaking as 50% Native Hawaiian mother, pure Hawaiian, 20th generation Native Hawaiian, I grew up when it was illegal to speak Hawaiian. And to have a Hawaiian expert on the Board of Education, to me, is highly necessary. You need the expert to guide the Department of Education. And the Hawaiian group is willing to put forth their expert who will totally represent them and represent our students is necessary. It's a time that we honor the Constitution that says Hawaiian and English are the native language of Hawaii. And in my opinion, as someone who missed out on learning my language, this is an opportunity we give to our children in Hawaii and the parents who so wanting their children to learn the history, the culture of being Native Hawaiian. It's key. This is our homeland. Why not have an expert on the Board of Education to guide the guidance of the DOE?
Thank you for that passionate response. After 53 years of being a teacher, if we pass this bill, will you come back out of retirement?
Oh, I'm still teaching. I'm
Oh,
still
you still, oh my goodness. Oh, ikalamai. Sorry about that. Thank you, Chair.
still teaching.
Thank you, Laverne.
Okay,
You are,
thanks.
wow.
Yeah, Replo Presti.
Thanks, Chair. Is the Board of Education here? Is there a representative?
I don't think we have a Board of Education testifier today.
Well, I guess it was at the HSTA.
That was HSTA.
Yeah, I guess I'll ask her. So I appreciate the intent, and I certainly see the value of having a Native Hawaiian language expert on the board. But similarly, there's great value in having a mathematician on the board. There's no mathematicians on the board. There's no, I think, English speakers or English language teachers. There's no history teachers. There's no PE or humanities teachers. What's to stop this from snowballing into something where we're required to have somebody from every single subject? I mean, I liked the point that the BOE made in their comments that, you know, this is something that the governor, I think, should actually include, and the governor should think about appointing somebody with that expertise, but to legislate it seems a bridge too far. And largely for me, because I do think I share this opinion, at least I thought HSTA shared the opinion too, that the Board of Education should go back to being an elected board, in which case then this kind of thing becomes difficult to enforce. I just kind of wanted your response on that. I don't know if there was a...
Just to be clear, Laverne, that question was to you.
Yeah.
Okay, first of all, the Hawaii State Teachers Association, the Board of Directors support this issue. It's in the Constitution. We are honoring the Constitution for the state of Hawaii. If we became an elected school board, the HST, I'm almost positive, would support a Native Hawaiian running for the at-large position. It is important. Why not a math teacher, history teacher, all science teacher? Because we are honoring a promise made by the 1978 people who were working on the Constitution. Native Hawaiian language is known as the language of Hawaii. Why not perpetuate it with someone with expertise? That's
Okay,
my take on it.
thanks. I don't see why this is necessary to do that. I think we can do that without it. I think we should do it. I think absolutely we should do it. I just don't see, I don't see why this is necessary. Thanks.
Members, any other questions?
Quick question, Chair, if you don't mind.
Yeah. Brett McKelvey.
Yes, hey, no, I don't know who would this be, I guess, for, but, I guess my concerns are that you have one group that would be picking the Native Hawaiian representative on the Board of Education. And there's numerous groups, in Maui in particular, that have expertise in this area. And I just would like to know, I guess, the feedback or as to why it wouldn't be opened up to numerous groups or entities or individuals to perhaps be chosen to fulfill that spot.
Kananeo Nohea, that might be a question for you.
Hi, aloha. Thank you for this question. So for the Aha Kauleo, we have membership with representatives, teachers, parents, administrators, so principals from each of the 27 Kaiapuni schools. So it's very on the ground, the information that would come to us, to the Aha Kauleo, with those memberships within the Aha Kauleo.
What if a follow-up? I mean, I guess in saying, what if somebody who is not associated with the Ahu Koleo, if were to say, hey, I'd like a chance to serve. I'm an expert in Hawaiian language. I've worked with children. I'm an educator. I mean, do you think the bill should be amended to allow for outside entity or people who may have an interest in fulfilling that role to be considered too?
We have had some discussion about that, whether it would be enough to be a Hawaiian scholar or maybe a Hawaiian culture practitioner, but Kaiapuni is very unique and very different. There's also not a lot written about it, so you really have to be inside of Kaiapuni to have that knowledge from experience of being in Kaiapuni. So we feel that it's not enough to be a scholar, a Hawaiian scholar, or a cultural practitioner. They really have to have that Kaiapuni insight.
All right, thank you, Chair, for allowing me to ask the question.
And members, any other questions? Okay, seeing none, we'll move on to HB 2125 HD1 relating to official school business. First up, we have the Department of Education in support.
Good afternoon, Chair Nakamura. No, I'm sorry, Chair Nakashima. My apologies. Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. Keith Hayashi, Interim Superintendent, Hawaii State Department of Education. The department supports House Bill 2125, House Draft 1, and appreciates the legislature's support in ensuring the safety and well-being of our employees and students. The passage of this bill will help to address the growing problem of harassment and threats that our school leaders and staff have been facing. The unruly behavior of individuals outside of school disrupts the school environment, causes fear and anxiety in school officials, and undermines the school's ability to conduct business. The department needs the ability to further protect its administrators from harassment as they work diligently to maintain a safe and healthy learning environment on school campuses, especially in the face of fluid and changing circumstances brought on by the ongoing pandemic. Thank you for the opportunity to testify. Mahalo.
Okay, thank you. And we have another DOE individual, Reed Kuba. Is Reed there?
Yes, I am.
Yep, go ahead.
Thank you. Chair Nakashima, Vice Chair Matayoshi, and the members of the Judiciary and Hawaiian Affairs Committee. Thank you for the opportunity to testify. I'm also part of the Department of Education, principal in residence, working directly with principals. So today I represent 124 other principals from across the state that support HB 2125. I just have one comment in addition to our written testimony. I'm not certain if teachers or school office workers know about this bill, but I'm certain that if they did, there would be thousands of more supporters because they've all experienced or know of someone at schools who experienced threats and harassment that have crossed the line. As you know, schools should be and need to be a safe place for everyone on campus, and not just the students, but everyone. So other than that comment, stand by our written testimony and stand by for any questions. Thank you.
Okay, thank you. Next up, we have the Hawaii Autism Foundation in opposition. You're muted.
I'm with the Hawaii Autism Foundation, and we represent hundreds of families. These are the families that have a relationship with schools. They do advocacy and IEP meetings all year round. I'm pretty shocked that the Department of Education, those two individuals were talking about fear and harassment when this bill actually harasses parents. There's no doubt about it that this is a harassment against parents. We have a right. First of all, we don't even have an elected school board, and we don't have an elected superintendent here. So our direct relationship is with the schools, and to make a misdemeanor of parents is a shocking misuse of justice. And I'm thoroughly against this bill, and so are all of our parents. We represent thousands of parents. We don't make harassments. We don't make fear. I've had my daughter in public schools here for years, and I've never once seen a teacher scared of the way that these people are saying it. I believe that they're exaggerating, and I just don't think there is anything but something that came down from the governor's office, and it's a misuse of power. It's definitely a misuse of power, and this bill cannot criminalize parents. It's absurd.
Okay, thank you. We have another individual from the Hawaii Autism Foundation, Julianne King. Is Julianne here?
Yes, Farmer.
Okay, not present. We'll move on. Susan Davis.
Hi. I'm also opposed to this bill. I've testified on it before. I've given it a lot of thought from my last testimonies. And the reason I oppose it is I do not believe the department has the authority to enforce this, nor assign the offender a misdemeanor charge. I do agree that a well thought out solution would be a better avenue to take. This committee needs to discuss the ramifications of charging a school community member with a misdemeanor. I think this is a slippery slope that we do not want to go down. This is an easy out rather than finding a solution. It's also not clear how the charges would be served. Would it be HPD? And how the process would take place in real life. If HPD is called, I believe they could de-escalate the situation. And if not, then other measures could be taken. But DOE is not law enforcement. DOE is not trained for this type of circumstance. I say call HPD and let them handle it case by case. This is not the time to get enemies out of your public constituents. It's also not the time to create havoc in a time of the continuing pandemic. I think the DOE is asking for way too much oversight in having the input on charging individuals with a misdemeanor, and the results and ramifications of this are going to start ringing out if this gets passed. Just give it a little bit more thought. I do believe that there's a well thought out solution. I just don't believe it needs to be a misdemeanor. Thank you for your time.
Okay, thank you. Next up, we have Louis Ma in opposition. Okay, not present. Next up, Kapua Medeiros in opposition. Okay, also not present. Shireen Ono in opposition. Shireen, nope. Okay. Well, let's see who's here. Tiana Wilbur in opposition. All right.
Hi, I'm present.
Yep, please proceed.
Hi, thank you for the opportunity to testify. I sent a written testimony as well. So I oppose this bill because, like other individuals had already stated, it's definitely not a scenario of teachers and educational staff members in threat of any kind. I keep a very close communication with my child's teacher, as well as the principals, and I was taught that from my parents, and they've always been very involved in my education. And my teacher actually encouraged that when my son was first enrolled in her classroom. I wanted to know what the curriculums were and what exactly they're teaching and how they're teaching it, just in the basic subjects in math and everything. And then also the issue that I know nobody really wants to talk about, but them enforcing and encouraging same-sex activities being taught in schools, which I don't teach my kids these things at a very young age, even boyfriend, girlfriend, anything of the matter, because they're too young.
Yana, we're losing your audio.
I'm sorry. Can you hear me?
Yep, we can hear you now.
Okay. So I just, it definitely, it takes away our rights as parents to monitor and be involved in what our kids are learning, what our children are learning. And I just spoke to my son's teacher today, and she is not aware of this bill, and nor would she be actually in support of this bill, because she likes that, I'm sorry, communication with parents, to know and to be more involved, because that's primarily in a lot of communities. The problem nowadays is that you don't have the support and the involvement of parents, especially through this pandemic. You can't even have our Ohana nights or whatever it is, like activities as a community because of the pandemic. Like, this is just taking away even more of that. And so, like I stated in my written statement, number one, it's unconstitutional. And so I just strongly don't agree with this. And there shouldn't even be another thought about it. You guys should just disregard this and not bring it back up again.
Okay, thank you for your testimony. Next
Thank
up, we
you.
have Jamie Detweiler.
Aloha. Thank you, Chair Nakashima and Vice Chair Matayoshi and members of the committee. Thank you for this opportunity to testify. I firmly and respectfully oppose House Bill 2125, harassment of an educational worker, and that it being a misdemeanor. I also want to make it very clear that I strongly oppose the harassment of any individual, including educational workers, as defined in this bill. There are current policies and procedures in place at the DOE and BOE to address harassing behavior, such as contacting campus security and HPD. A misdemeanor is a serious offense. Hawaii has three main classifications of criminal offenses: felonies, misdemeanors, and petty misdemeanors. Non-criminal offenses are called violations, which only carry fines, forfeitures, or the civil penalties, excluding imprisonment. There are many resolution options to address matters involving conflict. As defined in the bill, a person commits the offense of harassment of an educational worker if with intent, quote, to harass, annoy, or alarm an education worker. That person disrupts or interferes with the administration or functions of any school, school admin, or school board. Who's going to adjudicate this? I think a previous testifier spoke to that as well. A parent or guardian may present to staff in an upset manner, agitated, or passionate about matters concerning their child. As a parent of a DOE student in the past, all of my children have graduated proudly from Hawaii Public Schools, and I'm a proud graduate of Hawaii Public School as well. But there are different ways to address this matter. This may be perceived as harassment. Perception is either real or not. Providing in-service training to education staff on how to de-escalate a conversation and provide resolution options would be a positive approach. Reaching resolution through collaborative discussions using mediation and conflict resolution tools are far better than entering into the legal system, which is
Jamie, that's been 2 minutes. If you could conclude your testimony, please.
Right. I also want to emphasize, as a previous speaker said, this is an encroachment on our First Amendment rights, our right to freedom of speech. There are much better ways to address this issue in a non-legal environment. Again, thank you for this opportunity to testify. I yield. Mahalo.
Okay, thank you. Next up, we have Patrick Watson in opposition. Not here. Next up, we have Tabitha Kuhahiko in opposition.
Aloha, thank you for letting me have this time to testify. As a parent of 4 children and a Hawaii taxpayer and contributor, I am in strong opposition to House Bill 2125. I am upset and do not endorse this agenda in silencing parents, especially if what is being taught in schools goes against our family values and morals. I believe that parents play a vital role in what our children are learning, particularly that of what kind of curriculum schools are using to teach our kids or our keiki. So if I interfere by questioning what my children are learning in class, I can be charged with a misdemeanor and put in jail or be fined $2,000. This is not pono, and I oppose it. Please vote no on House Bill 2125. Mahalo.
Okay, thank you. And that is all the testifiers we have today. Members, any questions?
Chair,
Yeah, Rep. Lopresti.
I have a question for interim superintendent.
Hello.
Hi. Seems to be a lot of misinformation about this bill, at least as I understand it. Do you foresee any case where a parent simply bringing up or contesting what's taught in the classroom is in any way going to become harassment like this?
No, thank you very much for the opportunity to clarify. This bill is not intended, definitely is not intended to apply to rational disagreements between parents and schools, but is intended to apply to those individuals who absolutely cross the line of civility and thwart school operations by harassingly threaten using intimidation tactics and coercion on school officials. That's the intent of this, and it is not intended to thwart any kind of rational disagreements that should be happening between schools and parents to come to resolutions, which is in the best interest of the student, as long as it's rational. What this bill is intended to address is those harassing threats that are made to an individual's personal safety. That's the intent of this.
Thank you. And then as a follow-up, and I, Chair, if you'll indulge, I have a follow-up then for one of the people who testified against, but what about,
if it's is this a follow-up to Mr. Hayashi, or is I just don't want to, if it's something totally different, we should come back to you after we give Rep. a chance.
Okay, I'm gonna just, thank you. I have more questions for him. So given that it's not the intent to do that, what is the purpose of the bill, given that presumably one might say that harassment of such behavior is already covered under the law? Because in general, in principle, I support the bill, but why would we need this in addition to statutes that already cover harassing behavior?
Thank you very much for the question. Currently, existing laws don't address educational workers who have become victimized by irrational and compromising parents, and individuals whose actual goal is to taunt, harass, and intimidate school officials, so that they give in to unreasonable demands, and through coercion, and that's the intent of this. So my understanding is that currently existing laws do not address this in a manner which these individuals can be held accountable.
So what about possibly removing the word annoy? Because that seems rather subjective, and it still seems to still capture the intent of the bill. Because annoy, though, I think seems really subjective, and I don't know that that's in statute for harassment statute anyways, but what do you think about that?
I think the department would be open to eliminating that word, as it would be the committee's decision. But the department would be open to that.
I'm really open to removing that word, but support it in other ways. I'll defer back to my colleagues. I'm sure they have questions, and they'll probably cover some of the questions I had anyway.
Thank you, Member Lopresti.
Chair.
Yeah, Rep.
Ward. Thank you, Chair. Mr. Hayashi, continuing with that line of questioning, clearly, if you feel as strongly as you do about this, you must have some ball scores. You have the number of threats that the teachers or workers have had, or the number of harassment cases to build and put this into statute?
Thank you very much for the question, Member Ward. I don't have the overall number of cases. I definitely can get that to you. I am aware, though, of specific cases that have risen to the level of personal threats to our employees, that seek to compromise their personal safety, the safety of their family, and safety of the school.
And you're saying you've got some anecdotes from a couple of cases, but you don't have any numbers as to the statewide and the notion that this needs to be put into statute. Are you saying that you don't have any empirical evidence other than a couple of anecdotes?
I don't have the numbers for you right now, Representative Ward. I definitely can get that to you. I do know in the short time that I've been here, the semester, 6 months, there have been cases that have risen to the level of concern that I strongly feel that it's important to protect the personal safety of our employees, that this bill be seriously considered for passage.
Are you familiar with Loudoun County and what the parents and the Board of Education went through?
I'm sorry, you're broken up.
Are you familiar with Loudoun County and what the parents and the Board of Education went through?
No, I'm not familiar with that.
You're not familiar, because it sounds like this bill comes right out of Loudoun County. But the question related to that is, who determines if someone is a threat or somebody is harassing? You deputize your teachers as law enforcement? In other words, how do you implement this? It's a very practical thing that all legislators have to consider.
Definitely not. It would not be for us to deputize anyone. It would be for us to follow current practices and processes that are in place with law enforcement, and those in the decision-making positions to implement this should this become law, it would be up to them to then make decisions in line with this bill, or should it become law of this law. It is definitely not for the department to be deputizing anybody to interpret it. We would follow current processes.
Lastly, Mr. Hayashi, you realize the highest correlation with student achievement is parental involvement. This bill throws a cold water in the face of the parents to don't get too involved and back off, which otherwise the students are going to suffer, because the highest correlation of student achievement is parental involvement. If the parents don't care, the kids don't care. So if we've got a bill like this saying, oh, gee, I may not say this to my teacher, or I may not object to what is otherwise we've got a sexual creation. We have another bill that says you got to learn all about other kinds of sexual behaviors, positions, and other kinds of things. And when they object, you could pull this bill out and say, hey, you're harassing or you're threatening. Do you see what you're starting as a kind of a domino to breaking up what otherwise parents and teachers have at least a modicum of civility in terms of a relationship? You're now putting the law and splitting them apart.
Thank you very much for the question, Representative Ward. The intent of this bill definitely is not to interfere with normal communications and with parents. I definitely agree with you that communication with parents and parent involvement in a student's education, together with the school, is definitely very, very important. And the department takes that very seriously. We look at various ways to engage with our parents in a very productive and a manner that is always looking in the best interest of our students, most definitely. Again, the intent of this bill is to address those specific threats and harassing tactics that cross the line of civility that our administrators and our teachers and so forth have been subject to. And that is the intent of this. It is not, definitely not the intent to minimize.
To believe you, Mr. Hayashi, I've got to see the numbers to believe you, but thank you for putting your teachers out front. But look, parents are as important as teachers, particularly if you understand what happened in Georgia, when the government said, you have nothing to do with teaching, we are the teachers, sit down and shut up. I think this is going to be really a flammable issue if we don't get through it in this hearing. Thank you very much for your testimony. Thank you, Chair.
And Superintendent Hayashi, if you could get that information to Chair Nakashima, he can distribute it through the community, through the committee. Rep. Tokioka.
Thank you, Vice Chair. Superintendent Hayashi, thank you so much for answering the questions and for being here. I would also agree with my colleague from EVA on the word annoy. And I would also see that we should probably add alarm, because I don't know how you would define alarm. Because when I read the bill, I was like, annoy and alarm. How am I going to identify that? So would you have a concern with that, those two words, if that wasn't in the bill? Because and I'll tell you something, and sometimes my colleagues annoy me, but that doesn't, and I probably annoy them, but how do you define that in a situation like this when it becomes a misdemeanor?
Thank you very much, Representative Tokioka, for the question. Would it be feasible then to change the word alarm to shock?
Well, we can still, this bill has a long way to go. It's still on the House side, so you're going to have a lot of other committees to go through this. Okay. But I understand, I understand what the representative from Hawaii Kai is talking about. But I also feel that we need to protect our teachers, because they go through a heck of a lot of frustration. Sometimes, in very few cases, the teachers act out at parents, but it gets to a tipping point. But I know we still need to protect them, and so I think that's where the conundrum lies: is how do you balance the two? And I think to balance it, you have to make sure we put the right words in there, and that's what it's about. It could be shock. I think without those two words in there, there's enough to. Harassment is kind of a vague word, but it's a stronger word. So that's where it lays at, Keith, is which of the words do we choose, and how it's perceived. Because once this becomes law, whoever it is that's going to be policing this has to have the right tools to make the best decision for that circumstance.
Thank you very much, Representative Tokioka. The department would be open to your suggestions also.
Okay.
Thank you. Thank you very much.
Thank you. Any new members want to ask a question? Otherwise, I'm going to be going back to Rep. Lopresti. Rep. Lowen.
Yes, I have a quick question.
Sorry, for Superintendent Hayashi, did you run? I'm not sure what the genesis of this bill was, but or if it came from the DOE, but had the terms annoy and alarm been run by Attorney General or somebody? I mean, I guess the question I have is what's the legal definition of annoy or alarm, and how would that be determined in a court?
Thank you all very much for the question, Representative Lowen. We did work together with the Attorney General's office to help draft the language in this bill.
Okay, and they were comfortable with the language?
Yeah, yes, they were.
Okay, all right, thanks.
Thank you very much.
Okay, Reverend Kelby, did you have a question?
Yeah, yes, I will. First of all, I'd like to get a copy of the thing from the Attorney General's office saying that they felt the words alarm and annoy were legally sound to put into a bill. And the second thing is, I guess the question to wheel back is, you claim that the harassment laws that are currently on the books now don't apply to teachers or to school workers. I did a quick scan of the HRS and didn't see any exemption for people who are educators or school administrators or everything under the harassment laws. So why would you need a separate and albeit much more broader law on the books to protect against threats of bodily harm or harassment that, you know, can be brought against individuals who do it anyway in our society?
Thank you very much for the question, Representative McCulvey. For this particular, the language in this bill speaks to as individuals are threatened, school officials, and how it then impacts the operations of the school, and to be able to effectively address the needs within school operations as these threats, personal threats, are being made. The language of to your first question, I believe it is in the language of the administrative package, but we definitely can get that to you.
That would be great. But again, okay, somebody comes on campus, they make a threat of bodily harm or a threat, police are called, and you're basically, I'm pretty sure that if that were to happen, the charges would be pressed against this person. The police would then arrest them, escort them off, and then you would be able to pursue criminal action against them for doing it. I don't see how this bill will now give you a new, you can already do it if it's a threat. But what worries me about this is harass. Even the word harass isn't defined. It could be general. It could be, I just texted one of my colleagues, my gosh, under this thing were law, my CAS would probably have me arrested several times over for harassing and annoying and alarming. You know, so I have a lot of concerns. I agree with Rep. Tokioka. We want to protect our teachers. We don't want them to be facing with undue coercion or threats, but we have, I believe, strong laws against harassment. If incidents happens now, police can be called and charges can be filed. I guess that's where I'm kind of coming at right now, but appreciate you being here, sir. I know it's a tough subject. Thank you.
Thank you very much for the question, Representative McCovey. I also have with me here in the office, our risk manager, Russell Suzuki, who has been working closely with the Attorney General's office. So if you would permit me, Chair and Vice Chair, if I can ask Mr. Suzuki to share, would that be okay?
Is that in response to Rep. McKelvey's question?
Yes, it is.
Yeah, please do.
Okay, thank you. I'm going to just turn my computer. Thank you very much.
It's like right there.
Can you see me? Thank you. Yeah, just to answer a couple of the questions that has arisen here. The Attorney General's office did participate in drafting the legislation, and it was included in the governor's administration package. So it has approval of the governor and the Attorney General in this matter. To answer your question regarding this specific bill, it's not just harassment, but it also includes the component of interfering with the school's operations. And what we mean by that is that there are certain parents, adults, and this law is strictly focusing on the adults, has nothing to do with prosecuting students. But when a parent also interferes with the operations of the school, for example, clogging up the voicemails with threatening voicemails, also not accepting legal notices for hearings. For example, in special education cases, the department is required to conduct their hearings and meetings in a timely manner, or else they violate the IDEA, the federal law. Parents, such as the ones that we're talking about, refuse to accept emails, telephone notification, or written notification on purpose in order to force the department to be in default, and therefore they can just coerce the department in getting the results of what they want. So that's the reason for this bill. It's only for a certain amount of individual parents who use the system to force the department to not be able to comply with federal laws and state laws for timeliness. as well as to clog up the emails, clog up the voicemails with threatening email and communication. So that's the whole purpose. It's two-step. Not only do they harass, but they also interfere with the operations of the school. So that's the difference between this legislation and the regular harassment legislation. Thank you.
Well, I appreciate the edification on that. I'll just keep, I know Chair's got other bills, I'll just keep it quick, but I still, if you make a threat on a voicemail, that's evidence of threatening, and that can be, charges can be brought. And I guess I'm also a little concerned that, you know, as annoying as it may be, there are due process rights involved with hearings and such. And sometimes, you know, these things take longer time, but we have to respect that. But again, I appreciate you turning the camera over and giving me more of a background. Thank you, Chair, again, for the extended questioning. I appreciate it.
Okay, let's go back. Any other members that have not asked a question yet that would like to ask a question? If not, we'll be going to Rep. Lopresti.
Thank you, Vice Chair. So back to Mr. Hayashi, the gentleman, was it Mr. Suzuki, I think you said? I had a question for him. So, and I wanted to clarify when I had brought up, you know, annoy, I'm also talking about what Rep. Tokioka and McKelvey were talking about regarding, how did the wording go? Alarm. That's such a broad thing. I mean, because these things are recorded, and because when cases go to court and they look at legislative intent, I would say my view and my intent, if I end up supporting this, is not to make it so that anybody does not have a right to be offended, or a right to not be offended, right? I mean, by any stretch of the imagination, I'm annoying and can be alarming to some of my colleagues just because of my mannerisms and the way I talk. Sometimes some people might use colorful language, and in one household, that's a normal conversation at dinner. And another one, if you just use the word damn, they think they're somehow threatened all of a sudden, which I think is a bit much. So we need, I think, to remove alarm. We need to remove annoy. The good thing about this is that the bill talks about intent, and that's a pretty high bar. And so I agree that we might need this bill for the intent to disrupt administration and functions of the schools. But maybe harassment isn't the right way to characterize this, because as Rep. McKelvey rightly pointed out, as I was looking it up too in the interim, it's already covered by the law. So I would feel comfortable with voting on this once I have an AG opinion in my hand about this stuff, and also something I think written from you guys, helping to rewrite number 1, section 711 and number 1. To address the main point, if that's the main point, which is disruption of the function of a school. Is that something you guys can knock out pretty quick, or?
Thank you for the question, Representative Lopresti. We will work with the Department of the Attorney General on that.
Right.
Thank you.
Yeah, thanks, Chair.
Rep. Ward.
Thank you, Chair. For full disclosure, I want to plead guilty to being one of the people who annoy Reps Hawaii and other areas, as well as the Big Island, and all those smiling on this, because even the chair, I asked too many questions, so I have to be very quick. Mr. Hashi, back to you. We're talking about nuancing in words of annoy and threat and shock and alarm. I'm considering, would you consider taking this from a criminal misdemeanor $2,000 or a year in jail and give it a slap on the wrist, something that is more disciplinary, like the teachers do to the students in the classroom. They don't send them to the principal's office until they tell them, sit down and shut up or do something. Whereas here, you're criminalizing immediately. So what's the rush to do $2,000 and to do a year in prison? And maybe this is Mr. Suzuki, being that his fingerprints are all over these quote charges. In other words, can you lighten up a bit, Mr. Hayashi, or Mr. Suzuki?
Thank you very much for the question, Representative Ward. I believe there is a difference, though. When an individual at a school threatens the personal safety of an employee, whether it be an administrator or a teacher or anyone on campus, that threat to personal safety and the safety of that individual and the individual's family raises the
I think
the
Mr. McKelvey already covered that in his testimony
offense.
about you call the police, you file a case. I mean, that's already covered. So I'm not sure what you're saying.
Yeah, so when you refer to a slap on the wrist and you asked me for that about that question, I don't believe that the threat is a threat to an individual is not the same as a slap on the wrist. That should be raised to a higher level and a higher standard.
Okay, how about a couple of warnings? How about a couple of warnings before you slap them in jail?
When a personal threat, a threat is made to an individual and a school employee, I don't believe that that would be for the purposes of this bill, an appropriate consequence for that or appropriate.
Okay, go for the jugular. Chair, I have another question to Tiana, but I will pass until you go third round. Thank you, Mr. Hash.
Sure, thank you.
Members, if you'll indulge me a question in the meantime for Superintendent Hayashi, I think I can maybe clear up a little bit. It sounds like Rep. McKelvey and other members have concerns because of the existing harassment laws on the books that can be applied to the teachers. What it sounds like, though, is that Superintendent Hayashi, that you're referring to more harassment of the school as an entity, preventing the school from functioning by filling up voicemails, by sending too many emails, spamming, by refusing to accept notices for IDEA meetings and such. So I'm wondering if the point of this bill was to create a right of action for the school to defend itself against harassment to the school entity as an entity, as opposed to the individuals that are getting harassed. Because I think we can all agree that if a teacher gets threatened, and as a teacher, I have been threatened physically by parents before, that certainly falls under harassment laws that we have on the books. But if the parent or whatnot is harassing the school entity, not necessarily the individual, but by filling up voicemails and such, then maybe the school has no recourse other than perhaps through this bill. Was that the intent of the bill?
Thank you very much for the question, Vice Chair Matayoshi. That definitely was part of the intent of it, a major part. The other part, as I shared, is to protect our employees. And I totally understand what the committee has shared with us, but it is definitely what I shared and what you just stated. So thank you very much.
Gotcha. Okay, thank you. Members, any other questions? Otherwise, we'll go back for a final round of questions, I hope, since we're already about an hour into this committee and we're in bill number 2. Rep. Ward, did you have a final question?
Yes, Tiana, can you come on camera if you're still there?
Yes, I am still here. Thank you.
Okay, you're a mother of a couple of kids, right?
Yes, I am.
Let me ask you, I said slap on the hand or a warning or something. You know, there are some bad actors out there, and you know, the teachers don't need to have that necessarily as part of it. What would you as a parent accept as something that is remedial other than $2,000 in jail and a year in jail, $2,000 fine?
Well, I think that's definitely extreme, because I mean, I would consider that I would be stereotyped to a community that these things will primarily happen, and I have not experienced scenarios like they're trying to portray. So I want to ask Superintendent Keith Hayashi, what kind of scenarios are we talking about here? Because would a scenario, and I just want to use this as an immediate scenario that's taking place currently. If my child cannot go to school without a mask, and I take him to school.
Tiana, your volume is gone.
Sorry. Okay.
Yeah.
So can you hear me? Hi.
Yep.
Okay.
Got it.
So scenario, if my son cannot go, or I choose, or he has medical reasons why he cannot wear a mask, and I take him to school, he's now denied to go to school. And so if I go or I serve a document, or I stand on my constitutional rights, or my son stands on his constitutional rights, am I going to be reprimanded, or is it the story going to get flipped around to say, you are now coming to school harassing me as the principal, as the teacher? And I can say that that is not the scenario. It's all been peaceful. It's all been, and I know, okay, maybe there might be cases, but I am curious to see what numbers it is and what is the scenario of those cases, because I don't see that. It doesn't seem like this is a very big and heavy problem in our schools. And if you guys are trying to police and get parents to get more involved or to participate in what you're doing, why can't you just do it the way you guys are already? There's already resources and court systems in place with family court and things, and labeling them as neglectful for not following through in the things that you guys need them to cooperate with. So why is it that this handful of individuals is going to go and now open this big can of worms for all the other parents to be subject to their kids? Like, so this is my question is, are you guys be willing to drop in the amount of numbers in your enrollment in the next couple of years when this bill is passed, if this bill is passed? Are you guys willing to lose students in the public school system?
You're going to annoy the chair because he doesn't allow questions of testifying to the committee.
Okay.
But let me put it this way. In what you've said, are you saying we should not have any remedial or punitive thing if there is a spat between parents, which is obviously very normal? Or should there be something more like, as I called it, a slap on the hand, something that says, hey, cool down, parents?
Definitely a warning would suffice, because if, I mean, obviously if they don't get it, then maybe you can accelerate to the next, or, you know, move to the next thing, but.
Thank you, Tiana.
That's
Appreciate
too much.
it.
Thank you.
Thank you. Thank you, Chair.
Let's move on. I think we're beating a dead horse here. Let's move on to HB 2025 HD1 relating to the Sunshine Law. First up, we have, oh, Keith Hayashi, you're back. Department of Education with comments. Oh, I'm sorry. Is this the?
You skipped the student journalism one.
You know what? I think we have probably a testimony on this one. I'm sorry, members. 2125. 1848. Or 1880.
1848.
Oh, I'm sorry. This thing is, it's double-sided. It was that long. Okay, HB 1848 HD1 relating to student journalism, Department of Education with comments.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. My name is Raymond Fujino. I'm temporary assigned director for the Office of Curriculum and Instructional Design on behalf of Superintendent Keith Hayashi and the Department of Education. The department stands on its written testimony providing comments on this measure, and want to thank you for this opportunity to testify. Thank you.
Okay, thank you. Next up, we have the HSTA in support.
Aloha, Chair and members of the committee. Laverne Moore speaking on behalf of Osa Tui Jr., President of the Hawaii State Teachers Association. The Hawaii State Teachers Association supports House Bill 1848 HD1 relating to student journalism, for it gives them additional protection against censorship, and advisors need additional protection against retaliation for refusing to illegally censor student journalists. The Board of Ed has a policy regarding this issue. A policy is a frame for achieving certain goals. This law sets standards, principles, procedures that must be followed in Hawaii in regard to student journalism, and implements justice in our society. Hawaii needs a law that protects the First Amendment rights of student journalists and allows them the real-world learning that comes from making the decisions that must be made to produce a student-run newspaper. To support our teachers and students, the Hawaii State Teachers Association urges you to pass this bill. For this is Miss Reeves, the journalist teacher at McKinley High School, 6th year in organizing and advocating for the passage of this bill. Thank you very much for the opportunity to testify.
Thank you. Next up, we have an individual, Cynthia Reeves, in support.
Hello, thank you for the opportunity to testify today in support of HB 1848. My name is Cindy Reeves. I'm a journalism advisor I have a student here who must have had some problem with his testimony, and so he didn't get his testimony in or his link, Zoom link. I'm wondering if he can speak after me or I can yield my time to him.
Yep, sure, we can have him after you.
Okay, thank you very much. This week, student journalists around the country are celebrating Scholastic Journalism Week. And today is actually Student Press Freedom Day. So it's very exciting for me to be able to speak about this bill on this day. I was a high school and college journalist, and now I'm in my 10th year as the advisor for McKinley High School student newspaper. I want to tell you what a student journalism advisor does. I teach the students how to ask the important questions before embarking on a story. Questions like, is this subject newsworthy? How can this story add to the current conversation on this subject? What legal or ethical considerations are there? Who do we need to talk to get the story right? The one question I am lucky to not have to teach is, will my principal censor this story? We have a principal at McKinley who already supports me, my students, and the ideas in this bill. And this bill isn't an anything goes. It does allow the adults to stop publication of things that even professional journalists can't do, such as libel. This is not the case at all public schools in Hawaii. Current federal law and state policy make it easy for a principal to stop a student journalist from publishing something. In some schools, if a student journalist wants to write about campus vandalism, criticize a school program, explore issues of race and culture, they have been told not to. Those of you who were on this committee in spring 2020 might remember passing a version of this bill. It died in its sixth and final committee because of COVID. This year, we have a new set of students who have taken on the task to, among other things, tell the community how their school is coping in a pandemic. Not all those stories are positive, but they are important. Hawaii is not alone.
2 minutes if you could start to conclude your testimony.
Hawaii is not alone in the fight to bring a better learning environment for student journalists. New Jersey just became the 15th state to pass similar legislation. I ask that today, like in spring 2020, you pass this bill.
Okay, thank you. And do you have a student that would like to speak for? Okay, we'll give him 2 minutes.
Thank you, committee, for letting me testify. My name is Shane Kanshiro, and I am in my second year as a student journalist.
Shane, you're gonna have to speak up a little bit.
Okay. I am in my second year as a student journalist at McKinney High School, and I am supported in House Bill 1848. The opinion is currently 101 years old. Student journalists in the past have written about major historical events. They wrote about the truth from a student's perspective, and we're doing that right now too, even if it's controversial. Last year, I wrote about an article about the name change and of the resolution to change the name of McKinney High School. I'm proud of that article, and I learned a lot too. Our current law would allow a principal to censor such an article because it's too controversial. Luckily, our principal does not do that. However, this might be true for other schools. That's why these laws matter. Please support this bill. Thank you.
Okay, thank you. And last up, we have Althea Cunningham.
Hello, good afternoon. Thank you for this opportunity to show that I support this bill. My name is Althea Cunningham, and this is my second year as a reporter for the Opinion at McKinley High School. I'm also a senior JRTC cadet. In the news writing class, I've been taught press law, news value, and journalistic ethics. In JRTC, I've been taught leadership, integrity, as well as the law. I know the Constitution protects our free speech, but what about the free speech of the future generation? As an editor, I work with the staff to decide what stories to write. We responsibly covered issues and stories and events at our school, like LGBT, vaping, and vandalism within our school. The only thing we worried about are not breaking the law when we write, journalism ethics, and the needs of our readers. The thought of being censored is not any of our worries. I believe students around Hawaii deserve to have the same opportunity to be free of fear regarding censorship and backlash. I believe this bill will promote healthy growth and within our journalism community, help students be better reporter and citizens. Thank you, and please support this bill.
Okay, thank you. And members, that is all the testifiers we have on this measure. Any questions? Rep. Board.
Miss Cynthia? First testifier. Oh,
Yes,
there you
hello.
are. Hi, Cynthia. Thank you for testifying. Thank you for your experience. You must love it. You studied it. Now you're teaching it and guiding kids. That is great to see you in the profession. The question I have is, do you have any metrics on how often this occurs and what is taken? I thought the student that just testified after you basically said, hey, we were going to get censored, but we didn't get censored. So is this a preemptive strike that sending it to principals and vice principals, hey guys, don't touch our students? Or is there actually incidents and metrics that we can say empirically, hey, we're shutting down another generation? Question mark.
Yes, thank you for that question. I do not have numbers. I have anecdotal evidence from journalism advisors that I have talked to, is the direct answer to your question. But I think we cannot say that just because people haven't told us they're censored doesn't mean they're not censored.
Can you share some of the anecdotes so we know what we're really talking about? Because remember, we're codifying this for all the state of Hawaii, 1.5 million people.
Yes. So the three examples I mentioned in my spoken testimony here: campus vandalism, criticizing a school program, and exploring issues of race and culture. Those are three examples that I have heard.
But is it at Kaleo at the University of Hawaii? Is there a very renowned newspaper being Kaleo censored? Do they have a problem with President Lasner? Or is this in the DOE only?
I don't know about college. I do know that there was testimony from college media advisors supporting this bill, written testimony.
And who becomes the censor police person? Who decides what? You know, we've got all this stuff going with censorship, with say the wrong thing and you get off of Twitter and Facebook and other sort of things. We're kind of doing an equivalent of that with this bill, but who's the one who arbitrates the truth according to this bill?
This bill, so there are 4 things that would
4 criteria, exactly. But who's the one who decides those? It's 4 criteria. You can't be obscene, it can't be inciting, etc. But who decides these criteria are met or not met? Is the question. Enforceability.
At McKinley High School, it's me. There are some schools where it's the principal. And this bill allows for that process to still be done. Some principals say they want to see the paper before it's published. We call that prior review, not prior restraint, prior review. The principal says, I want to see it first. This bill spells out the reasons that that principal could say this can't be published. Right now, the reasons that a principal might give for wanting to something not to be published is so vague. This bill also says that that there needs to be a time frame. So if the principal does want to do prior review, that they need to get back to the student journalists in a timely manner so that they don't miss deadlines, because that's another kind of a sneaky way to censor things. You just hold on to it. The principal holds on to it long enough that the story is no longer timely.
Excuse me, Cynthia, would this include the valedictorians who say God and they can't say that and so they can censor it, or this would cover them also?
No, they're not student journalists.
Oh, the valedictorian, if the valedictorian was a student journalist, they would be able to do that? Or it's outside.
Well, I guess that then the questions would be the kind of questions I said. If a student journalist wants to, tell me again about the valedictorian.
I mean, some valedictorians mention God in their, final senior year, and they thank God, and then when they get this speech to the principal, it doesn't get cleared because it's got some quote mention of theology or some reference to religion.
Right. Let's say that valedictorian was a student journalist and was writing an editorial. That sounds like an editorial. That does not meet any of the criteria in this bill. That would not be censored. There's no reason to censor that kind
Cynthia,
of.
thank you for your input. I'd love to hear from the principals and those who are going to be the ones who actually enforce this and have which is already with a lot of power, whether they're willing to give it up. I'd love to hear their testimony. But thank you for yours, Cynthia, and thank you, Vice Chair.
Thank you, members. Any other questions? All right, if not, we'll move on to HB 1426, Hd1 relating to orders of the Campaign Spending Commission. We have 2 testifiers today. First up, the Campaign Spending Commission in support.
Thank you, Chair, Vice Chair, members of the committee. The commission supports this bill and we submitted testimony. I would just like to emphasize the point that the Department of the Attorney General, they enforce the commission order. And right now, the only way to enforce the order is going through the contempt process. So it's more of a criminal punishment. So it would greatly help the Attorney General's office if they could also pursue collections on a civil judgment. And that is the main purpose for this bill. Thank you.
Thank you. Next up, we have Common Cause Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We do support this bill. We just proposed one amendment, and that is in our written testimony, and I won't belabor the point here. Thank you for having Common Cause Hawaii testify with a suggested amendment. I'm available to answer any questions. Thank you.
Okay, thank you. Members, any questions? If seeing none, we'll move on to HB 1427 relating to reports filed with the Campaign Spending Commission. First up, we've got the Campaign Spending Commission in support.
Good afternoon again, Chair, Vice Chair, members of the committee. The commission will stand on I will stand on the commission's written testimony in support. Thank you.
And that's all the testifiers we have. Members, any questions? Okay, seeing none, we'll move on to HB 2416 HD1 relating to campaign spending. First up, we have the Campaign Spending Commission with comments. Sorry, 2416. I'm not sure if I said 2461.
Thank you. Again, good afternoon, Chair, Vice Chair, and members of the committee. The commission appreciates the intent of this bill. We think that this bill is very important in that it seeks to get the disclosures or the sources of dark money. We ask that you consider the amendment sought by the commission to Section 5 of the bill. We believe, well, what the bill does in Section 5 is basically it erases the requirement to report the person who paid for the ad or paid for the publication of the ad. The commission does not see that as being exclusive of disclosing the true sources of nonprofits' money or the money that is being spent on ads. In other words, you can have that, plus you can have the requirement that if you have someone who paid for the ad, then you have to disclose that person. Other than that, I'll just stand on the rest of the written comments. Thank you.
Thank you. Next up, we've got AG's office with comments.
Good afternoon, Chair, Vice Chair, committee members, Deputy Attorney General Candice Park on behalf of...
We can't really understand you. It's a little muffled. I don't know if you can move your mic or something.
Is this better?
Oh, not really.
Okay, let me try something else. Is this better?
Is everyone else having a hard time hearing her? Yeah, I
Yes,
think we're all having
definitely.
a hard time.
It's like the New York Metro.
Yeah, Candice, why don't you try logging off? We'll come back to you. We've got two other testifiers. We'll come back to you. Why don't you try logging off and logging back in? Hey, just keep an eye out for her. Thanks. Okay, let's go on to Common Cause Hawaii with comments.
Good afternoon, Chair, Vice Chair, members of the committee. Common Cause provided comments with concerns about HB 2416. As the committee knows, Common Cause is a major proponent of robust campaign finance disclosure laws. We are not clear as to why this bill, HB 2416 HD1, only is targeting C4s that have to register as non-candidate committees. This will just drive the spending in our elections to other organizations, other non-candidate committees such as PACs and super PACs that don't have to register as C4s, chambers of commerce, unions, all these other organizations, and will not have the intended effect of having transparency and accountability in our elections. So we don't really understand the purpose of this bill of just targeting C4s, it will not, we don't believe have the intended effect when it should cover all persons. And so those are our comments and concerns about this bill. We do appreciate a robust campaign finance disclosure laws, though. Thank you very much. I'm available to answer any questions. Thank you.
Okay, thank you. And next up, we have Sierra Club of Hawaii in opposition.
Good afternoon, Chair Nakashima, Vice Chair Malayoshi, members of the committee, Wayne Tucker with the Sierra Club. We are in opposition. Our written testimony does talk a little bit about the unintended impacts or consequences that might result from a measure like this. And we definitely do appreciate its intent, but as we've seen in other places like California, as we've seen in other places like California, bills like this have resulted in some pretty adverse consequences for folks who, like in that case, gay marriage advocates, supporters who were trying to defeat Proposition 8. And a number of folks were essentially outed who had only contributed a small amount of money towards that campaign. Likewise here, there are folks that don't have the time to, come to take off from work to testify, to vet through candidates. And so they rely on the Sierra Club to kind of do that for them and identify and advocate for them through their contributions. And so, a measure like this would discourage that kind of participation. There are also folks that don't necessarily, like in the case of, for example, in the case of Red Hill, there are folks that are intimidated by speaking out on the issue and what's happening to them. And so, one way they could participate and have their voices heard is to support our work in this area. And a measure like this would basically force us to out people, and which is what a lot of them are really afraid of. And so, we do think this is a well-intended measure, but we are very concerned about some of the unintended consequences and impacts that a bill like this would have. So happy to answer any questions. Thank you.
Good, thank you. Let's go back to AG's office, Candace.
How's this? Is this better?
You know what? I think just go for it.
Okay, so thank you for the opportunity to testify. We submitted our suggested amendments and are available for questions.
Okay. Man, I have no idea what's wrong with that mic. Members, any questions?
Chair.
Yep, Rep. Lopresti.
Thanks. Sandy Ma. I assume you're still here. So my question is, so what are some of the C4s? I guess Sierra Club's one of them. I hadn't really thought about it setting up double standards, but I don't want to see that either. What are some of the other C4s that this might affect?
Thank you, Representative Lopresti, for that question. Common Cause is a C4, we have a C3, and we have a C4. We have not done any electoral work that would have us register as a non-candidate committee, but I cannot predict the future, and so we may. For example, HCAN has a C3 and a C4. HCAN has HCAN Speaks. ACLU has a C3 and a C4. There are lots of nonprofits in Hawaii that has both a C3 and C4. I'm not saying that they will all have to register as non-candidate committees, but nonprofits do have C3s and C4s. Thank you for that question, Representative Lopresti.
Thanks for that insight. So PACs would still be able to have dark money. What other kinds of things would still be able to have dark money?
So corporations could spend if they register as non-candidate committees, LLCs. Thank you again for that question. If you are not a nonprofit, such as a chamber is not a nonprofit, it's a different type of it's a different type of it has a different IRS designation. Chambers, unions, they can all still, they're not covered by this bill. Thank you for that question.
Well, and then I have some real problems. I mean, When you go through the beginning of the session, you're going through bills and you see something that's going to reveal dark money. Certainly want to jump and put my name on it, but now I have concerns. Thanks for pointing that out. This bill seems to be targeting the good guys.
I think that might have been the end of Replicate. Did you? Was that
Yeah,
the
that
end
was
of your
it.
questioning?
That's
Okay.
my editorial comment. Thanks.
Any other questions, members? Okay, if not, I've got a question for Sierra Club. And actually, Sandy, this might be for you too. From my understanding of this bill, it really targets electioneering communications or donations to candidates or your campaign contributions. In your opinion, and maybe this is a better question for Sierra Club first, when people donate to Sierra Club, do you think that they are they always donating to facilitate electioneering communications or candidate donations, or are they donating to other trail restoration or other things that you do?
I actually think, you know, the Sierra Club is one of the few organizations here that do endorse candidates. I think we're known for that.
Wait, you're coming in a little soft.
Oh, sorry. So I think the Sierra Club is pretty well known for the fact that we're one of the few organizations here that do vet through candidates and make endorsements. I think people are fairly aware of that, and we and it's pretty clear in like our Malamo and our communications with our members. We do have a C3. We have a C3 and a C4 too. So if folks want to, get a tax exemption, then they'll donate to our C3. But and those funds aren't, obviously aren't used for lobbying or electioneering. But I don't think, I'm fairly confident that our members know that a big part of our advocacy is helping identify.
But I suppose, how can you know unless you ask? And this bill really doesn't target Sierra Club doing advocacy like you're doing now in the state legislature. It really is, if you're sending out mailers on behalf of a certain candidate or advocating for a certain candidate, electioneering communications, that's where the rubber meets the road here. And that's where the dark money bill, I think, is trying to target. So if you haven't, and I guess this is the question, have you ever asked your members or your donors whether it's okay for you to use any part of their donation on electioneering communications to advocate for the election of a certain candidate?
Well, our members are, we have a newsletter that goes out, and so we try to include, we have materials that go out that indicate our endorsements. So, our members just have to ignore those. And
I'm assuming that they're aware of it, but would you consider the Sierra Club's primary function to be electioneering communications?
Not a primary function, but I think one of the functions that is relatively unique to what we do and our presence here.
You would consider it a primary function of the Sierra Club to send out electioneering communications? This is not advocacy. This is electioneering communications. I just want to be clear. So you're saying that one of the primary functions of the Sierra Club is to send out mailers on behalf of candidates or to do donations to political campaigns?
I don't know if primary is an adjective I'd use, but it's something that we've done in the past.
Okay. And just from an outside perspective, I wouldn't consider that one of your primary, you guys do a lot of good work. I would not consider that one of your primary functions. And I think a lot of people wouldn't either. Yeah, I think, Sandy, if you want to add anything, feel free.
In terms of Sierra Club's mission and goals, I cannot add
Or
to
not Sierra Club, but to Common Cause. Same questions. If you are donors to Common Cause Hawaii donating for your advocacy for certain issues, or are they donating to allow you folks to afford electioneering communications on behalf of candidates?
We are nonpartisan and we do not endorse candidates.
Okay. Then the question really doesn't apply to you. Thank you. Any other questions, members? Oh, I'm sorry. Let's go to Rep McKelvey first to give him a chance.
No, it's a follow-up actually to your question to Sierra Club. So this kind of is very similar to the Supreme Court case in my mind with the union dues. You know, could somebody who's donating to the C4 request that their donation not be used for any type of electioneering communication, since that's a subset of the C4 and that may cause concerns for them insofar as a candidate that they like may not be, may not be receiving that kind of electioneering communication support?
I don't think we have a dedicated fund now, but I'm sure we can set up a separate accounts.
It's like a checkbox. Yeah, you donate to C4 and it says a checkbox that says, please do not use my money for electioneering communication without my consent. So that something to that effect, or not at all.
Or even an affirmative checkbox, right?
Yeah, that's what I mean. Yeah.
Yeah, I mean, I don't think we wouldn't be able to do that.
Okay. Rep. Lopresti? I saw your hand went down. I don't know.
Yeah, I was going to try to answer to help Sierra Club. As the former political committee chair for the Sierra Club, and as former executive committee member of the Sierra Club, I'd never met anybody in the organization that didn't know that when they were involved that there was a political angle to it. I mean, is this line of questioning suggesting that we're going to make C4s put affirmative checkboxes on the things and to neuter them out of political involvement like unions have been neutered? I think that's a horrible idea. And
I think we can, if you want to discuss it, if this is a member-to-member discussion, maybe we could have it before we DM.
Yeah, I know everybody likes to have conversations behind closed doors, but I'm willing to say it.
I think I made my position fairly clear.
Yeah.
Okay, members, any other questions? Okay, if not, let's move on to HB 1475 relating to mandatory ethics training. First up, we have the Hawaii Ethics Commission in support.
Good afternoon, Chair, Vice Chair. My name is Robert Harris on behalf of Hawaii State Ethics Commission. We will stand on our written testimony, but are happy to answer any questions you might have.
Okay, thank you. Next up, we have DAGS in support. Yeah, you're muted.
I'm sorry, the bill we're discussing right now, I got lost on the list.
Oh, I'm sorry. I might have skipped. Robert Harris was on there twice.
Yes, thank you.
This is Common Cause Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee, Sandy Ma for Common Cause Hawaii. We submitted testimony in support of HB 1475, and we suggested some amendments to strengthen the bill. We are supporting this bill and would like to request that mandatory training be every year instead of once every 4 years, as there are new ethics laws and rules that could be passed by the legislature. And we also request that there could be consequences for those who do not undergo mandatory ethics training. Thank you very much. And I am available to answer any questions. Thank you.
Thank you. Members, any questions on 1475? Okay, hearing none, let's move on to HB 2069 HD1 relating to gifts. First up, we have the Hawaii State Ethics Commission in support.
Thank you, Chair. Once again, sorry, Vice Chair and Chair. Once again, we'll send in our written testimony. Happy to answer any questions you might have.
Okay, thank you. Next up, DAGS, you're up.
Thank you, Chair, Vice Chair, members of the committee. I am Dr. Adam Jansen here representing the Comptroller. DAG stands on its testimony, and as State Archivist, I really want to emphasize that we are the keepers of public memory, and these protocol gifts, which are very narrowly defined, have an immense political, cultural, and historical value that may not be necessarily reflected in their dollar value that's required for registering all of gifts. And because of this intrinsic nature, we feel it is imperative that these protocol gifts be registered and documented so that when future delegations come, we can bring these gifts back out to show the long and storied history between Hawaii and the visitors, and that the public can come and see these beautiful, important gifts that may have more important meaning to them as well. So I appreciate the opportunity to testify and am available for any questions you may have.
Okay, thank you. And lastly, we have Common Cause Hawaii in support.
Hello again. Good afternoon, Speaker, sorry, Chair and Vice Chair and members of the committee. Sandy Ma for Common Cause Hawaii. We stand on our written testimony in support of HB 2069 HD1. I'm available for any questions. Thank you.
Okay, members, any questions? All right, seeing none, we'll move on to HB 2303 HD1 relating to the Uniform Information Practices Act. First up, we've got OIP with comments.
Afternoon, Chair, members of the committee. Am I permitted to testify? Orally?
Yes, you're on the list.
Yeah, okay, thank you. Based on the Federal Freedom of Information Act, or FOIA, state and federal case law, and the UIPA's own legislative history, OIP for nearly 30 years recognized the deliberative process privilege as a form of an exception to the disclosure requirements under the UIPA. In 2018, however, the Hawaii Supreme Court, in a narrow 3-2 decision, overturned OIP's case law in their own case called Pure News LLC versus City and County of Hawaii. Interestingly, the majority and dissenting opinions in Pure News both relied upon the plain language of the UIPA and its legislative history, but came out with completely opposite conclusions. OIP has extensively analyzed both these decisions and realized that they were not informed of key legislative history, including prior court precedent at the time that they made their decision in Pure News. I think that the missing legislative history would have made clear that the legislature that adopted the UIPA in 1988 intended to leave it to OIP and the courts to balance competing interests to determine whether disclosure should be required in those gray areas and unanticipated cases that the law cannot cover in a statute. Contrary to the abuse feared by opponents, the deliberative process privilege had been constrained by no less than 10 OIP opinions and had been narrowly construed by OIP to be consistent with the need for efficient government operations while preventing the privilege from swallowing the UIPA's requirement to form and implement public policy as openly as possible. The DPP, or deliberative process privilege, did not automatically protect from disclosure all records simply because they were labeled drafts or because they were determined to be pre-decisional and deliberative.
Sure, that's been 2 minutes. If you could conclude your testimony.
Okay, so OIP implicitly recognized a balancing test. And the current legislature has the opportunity to return to the original intent of the UIPA by leaving it to OIP and the courts to carefully weigh competing interests. And this bill would expressly create a balancing test that even the successful appellant in Pure News and the dissent had argued should be adopted by the court in that decision. So ultimately, it's going to be up to you to decide which way you want to go on this. We do believe, however, that this bill represents a reasonable balance and would leave it up to you to determine. Thank you.
Okay, thank you. Next up, we have HPD in support.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and the members of the committee. I'm Major Joseph Trinidad of Honolulu Police Department. We stand by written testimony in support of this bill, and I'm here to answer any questions. Thank you.
Thank you. Next up, we have Common Cause Hawaii in opposition.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We submitted testimony in opposition to HB 2303 HD1. The purpose of the UIPA is to provide open government and to ensure open government processes to public scrutiny. We are concerned about having another exception to this. That is the gist of our written testimony. I will not repeat it any further. I'm available for any questions. Thank you.
Okay, thank you. Members, any questions? Yep, hearing none, we'll move on to HB 2025 HD1 relating to the Sunshine Law. First up, we have OIP with comments.
Sorry. OIP had offered an amendment to the proviso that we find confusing, and we still think that the proviso itself would maybe result in additional legal challenges and confusion. We already interpret the law to not require people to specifically name the minor children that may be running around in the background as they're going through these Zoom meetings. But we leave it up to you to maybe clarify what you really intend in this bill. Thank you.
Thank you. And actually, that's all the testifiers we have today. Members, any questions? Okay, moving on to HB 2026 HD1 relating to Chapter 92 Hawaii Revised Statutes. First up, we have OIP with comments.
Yep, I'll just skip over. We have no problems with much of this bill. It's up to you to decide. Where we do have some technical concerns are with the board packet deadline requirements, and we've proposed some language to clean up some of the confusion in this area. And overall, we just like the committee to bear in mind that we just went through a major change to the Sunshine Law last year that the boards are still trying to digest. So if you want to keep adding new changes, it might be really hard for boards as well as OIP to keep the boards informed and in compliance with the ever-changing laws. If you have any questions, I'll be happy to answer. Thank you.
Thank you. And last, we got Common Cause Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We submitted written testimony in support of HB 2026 HD1. We really like this bill. We worked on drafting this bill with stakeholders, and we think this is a good bill. We ask that you pass this bill out of your committee. Thank you for having Common Cause testify in support of this bill, and I'm available for any questions. Thank you.
Thank you. Members, any questions? Okay, seeing none, we'll move on to HB 1884 HD1 relating to the statewide traffic code. First up, we have Department of Transportation in support.
Mr. Chairman, members of the committee, the Department of Transportation is in support of the measure, and in the interest of time, we'd like to stand on our testimony. Thank you, sir.
Thank you. Next up, we have Honolulu Prosecutors with comments.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Department. We submitted our testimony comments supporting the intent, and we do understand that the intent is to hold ignition interlock, well, DUI offenders, essentially, who install ignition interlock as they should, to hold them accountable when they have violations on these devices and to ensure that they don't have the violations by the time they are able to get their licenses back. That said, the approach that's taken by this particular bill, we do have some concerns in that the way that it's crafted, well, one, it would essentially mean that somebody might not ever be able to get their driver's license back if they would have to continue to be on ignition interlock forever if they're not able to meet what the definition is of non-violations. Or what we're more afraid of is that people would actually then not want to get ignition interlock in the first place and take the other alternative, which is offered in the bill, which is a 2-year probation, revocation period. So in that sense, we actually think it would be a more prudent approach to encourage as many people as possible to get on ignition interlock, and then to perhaps incentivize them even further to do a good job while they're on ignition interlock. There's another bill you're hearing later today, HB 2247, that we feel does that, but we're available for questions if any. Thank you.
Okay, thank you. Next up, we have Start LLC in support.
Good afternoon, Chair, Vice Chair, members of the committee. Joanne Hamaji, Oto Operations Director for Start LLC, Hawaii Corporate Office, offering testimony in support of House Bill 1884 HD1 related to the statewide traffic code. We have long supported closing a gap in the current law, which allows people who have already pled guilty, been convicted, or administrative adjudicated to have been impaired while driving to continue to attempt to drive drunk without limit on the restoration of their license. This is not only wrong, but it's dangerous because a person who blows into an interlock device while impaired is demonstrating that they cannot yet drive sober. This bill recognizes that a driver's license is a privilege that should be granted only to those that can drive safely. We have heard the concerns raised about requiring an interlock device as a precursor to administratively restoring a driver's license. We want to clarify that we would be supportive of revisions to this bill if they're necessary to ensure that at minimum, those who do have an interlock device installed have a period of compliance required prior to removing to prove that they are sober to drive on our roads and in our community. It's about public safety, which should always be first and foremost. An indigent program is available for those that qualify to lessen the costs associated with an interlock. We urge you to pass House Bill 1884 HD1 to help save lives and to keep Hawaii roads safe. Thank you for the opportunity to testify on this important bill.
Okay, thank you. That's the last testifier we have. Members, any questions?
Chair.
Question? Oh, sorry. Go ahead,
Representative Presti.
Thanks. For prosecutor. So my question is, and my initial understanding of this, the way this is written, is it fair to construe it that it's penalizing people for being poor rather than just incentivizing people who can to use the interlock device? Would that be a fair description of how this is written?
I suppose that could be one way to look at it. In prior bills that were somewhat similar to this, but did not offer the 2-year revocation period alternative, our concern was that without that alternative, then everyone would have to get ignition interlock in order to ever get their driver's license back. And that we felt was penalizing people who are too poor to get ignition interlock. This, although I think it tries to offer that alternative for people who simply cannot get ignition interlock, then it almost seems to disincentivize some people who perhaps do not want to get ignition interlock and have to be violation free for 6 months or however long the bill would require.
It says prohibits from driving for 2 years. Isn't it 1 year right now?
Correct. For some offender, it's 1 year. Well, so another concern that we raise in our bill, although it's I suppose another concern we raise is that some people would already be could be subject to longer than 2-year revocation. So somebody who's subject to, say, a second offender who's already subject to up to 3 years revocation, it doesn't make sense that if they decide not to get an ignition interlock, now they're going to be subject to 2 years. It would conflict with the court's perhaps inclination to give them 3.
Well, yeah, and my point is that right now the penalty is 1 year. And frankly, if this were to pass and you didn't own a car, well, now you're just penalized to 2 years automatically.
That is true. That's not for our part. That's not necessarily our concern. We feel that if somebody is not going to get on ignition interlock, perhaps it would be an incentive for those who can, but simply don't want to get onto ignition interlock, for lack of a better term. We feel that having a slightly longer period revocation might be a good idea to help incentivize more people to get it.
And then one last question. Do those things work on motorcycles? What if somebody gets one on a motorcycle? The interlock?
I believe Smart Start would be able to address that, but our understanding is they can put an ignition interlock on anything with an engine, essentially.
Thanks.
Representative Kelty.
Thank you, Vice Chair. Appreciate it. For Smart Start or Spark Start, I guess if they're still here.
Yes.
Yes. Okay. You heard the prosecutor's office. Why this bill and not 2247? They clearly prefer 2247 as a way to address the public policy behind influence of an intoxicant.
What I can tell you is that compliant-based regulation is law in 34 states. It is about public safety. We want people who currently do have an interlock installed to show that they have a period of compliance, to show that they're able to drive safely, to be able to drive sober. And that is what we're asking for. It's about behavior modification to not drink and drive. And that's what the interlock teaches, for you to not drink and drive.
Okay, well, it looks to be the same except for this proof of compliance thing. I mean, 2247 says, you have to have that, but this proof of compliance, I guess, is the big difference. What is the proof of compliance? If there's no violations, like, for instance, when somebody blows the tube, is that what you mean by that? Or
Yes, the proof of compliance, it would need to be defined, such as, for example, no positive alcohols, and things like that. But it would.
What about mouthwash? I know there's been situations where people have triggered the video thing because they take mouthwash that has alcohol in it. Yes, or they don't blow the tube in time.
Yes, so there is no video on interlock. It's just a camera that takes a picture when the device cues the driver for a test. And mouthwash, we can determine from the report, and we have, that it is a contaminant, a mouth contaminant, versus a true consumption event. So we can determine that already, and we have done it previously.
Okay, thank you, Chair, for that. Vice Chair, for that.
Members, any other questions? Okay, seeing none, we'll move on to HB 1822 relating to driver's licenses. First up, we have the Department of Transportation in support.
Chair Nakashima, Vice Chair Matayoshi, the Department of Transportation is in support of the measure, and in the interest of time, we will stand on our written testimony. Thank you, sir.
Okay, thank you. Next up, AARP in support.
Good afternoon. I'm Audrey Sugan Nakagawa from AARP. We support the intent of this measure to extend the new renewal period for older drivers from 2 to 4 years, but we have some real concerns about the additional provision requiring medical certification for all people, all drivers 70 years and older. And that's noted in Section 2 under subsection 286, and again repeated in Section 3. This provision seems to be something that's based on age, and it's not based on a medical concerns, which may impact a driver's ability to drive. And I just want to point out in our testimony, a written testimony, we've noted that in the Department of City and County's DMV website, this type of medical requirements certification is not required for all the drivers. There's only an eye screening, and a medical certification is only warranted if the examiner of the driver feels that the person might have some inability to operate a motor vehicle safely. So to now impose this is contradictory of what this intent of this bill was. You're imposing more barriers for the older drivers, again, based on an age. It's going to require them to go to the doctor now to get an appointment, to get a doctor's appointment. And then it does cause additional costs, because that examination, if it's a full screening or full examination, it's going to be a medical cost. And so, it's really counterintuitive of what this bill is trying to do. So we really request that you reconsider of having this provision put into this measure. So thank you very much.
Thank you. And we have an individual here to testify in opposition, Charlene Watanabe.
Hello, I'm not in technology. I don't know. Is this good? Can you hear me?
Okay. We can hear you. You can proceed.
Oh, okay. Hello, I'm Charlene Watanabe, Kupuna. Thank you, Chair, Vice Chair, and members of the committee for allowing me to express my opposition to HB 1822. Studies have shown that vehicular accidents are caused by not only impairment, but also by speeding, distractions, such as use of or texting on cell phones, and drug use, accompanied by get out of my way behavior. 70-year-old guys, 70 to 79. Kupuna drivers are less likely to engage in the aforementioned reckless driving patterns. But thank you. I respectfully have you oppose HB 1822. Thank you very much.
Thank you. Members, any questions? Yeah, Rep. Nakamura.
Thank you, Chair. Just a question for AARP. If that section requiring a person over 70 years to also present a certification from a doctor is deleted from the bill, is everything else okay?
Yes.
Okay, thank you.
Okay, members, any other questions? Rep. Lowen.
Chair, I have a question.
Yes, for DOT. You know, I'm not sure what the genesis of adding this requirement for a doctor's note for anyone over age 70 is. For Department of Transportation, do you feel that's necessary? Do you have, higher, like, is there data to support why that would be necessary for any reason?
Representative, in our testimony, we recommend not requiring drivers age 70 or old. It's a second paragraph.
Okay.
Testimony. So we're
okay.
in tune with the AARP there.
Got it. Okay. So pretty much it seems like everyone's in agreement. This additional doctor's note, which seems sort of borderline age discrimination and also might add costs for people, is maybe not the greatest idea.
Yes, ma'am.
Thanks.
Rep. Ward.
Thank you, Chair. I was just researching the 5 biggest causes of accidents. And it starts out with saying distracted driving, speeding, drunk driving, reckless driving, and rain. And I was going to ask, Chair, the HPD, would they have what, in terms of their accident reports, the most frequent, or let's say the most, if there are medical ones that they have mostly chronicled? In other words, again, look, I like data. What does the data say about this other than some anecdotal stuff? Or do we have any at all?
The HPD is not present, but maybe the Department of Transportation might
The
be able
DOT,
to
Patrick, can you feel that one, if you will?
Sir, I don't know that I can feel that, but we have staff on the call. Is Lee Nagano available? Lee, can you weigh in on this, please?
Sure, could we second that to Lee?
Yeah. Good afternoon, Chair, Vice Chair, members of the committee. We could not find any statistics to prove that drivers 70 and older were any more dangerous than other drivers.
Okay, so in the lack of any evidence, we have evidence. Thank you very much. Thank you, Vice.
Thank you. Members, any other questions? If not, we'll move on to
Hey, hello.
Rep. Lopresti.
For DOT. So, forgive me if you could clarify your testimony then. So you guys, I'm also opposed to getting rid of the, I'm in favor of getting rid of the requirement for a doctor's note and a mental note, but you guys are in favor of expanding it from every 2 years to every 4 years too?
Yes, sir.
And right now it is every 2 years?
I believe so. Lee Nagano, can you weigh in if you would, please?
I'm trying to read the bill right now, and I don't see that.
Actually, if you're 70 or 71 and you renew your license, it's actually valid for 8 years.
That's what I thought.
But from 72 and above, yes, it is 2 years.
So please say that again more slowly.
Oh, sorry. Yes,
okay.
sir. If you're age 70 years old or 71, and renew your license, it would be valid for 8 years. When you're 72 and above, then it is 2 years.
I see. And this would expand it to 4.
Correct.
I see. Thank you for that clarification. Thank you, Chair, Vice Chair.
Okay, thank you. Members, any other questions? Good. If not, let's move on to HB 1453 relating to traffic violations. First up, we have the public defenders in opposition.
Yep. Good afternoon, Chair, Vice Chair, members of the committee. I am James Taga with the Public Defender's Office. We do oppose this bill. What's troubling is that a person who is stopped for a relatively minor offense can actually end up in jail for up to 30 days just because an officer doesn't believe the person say who he or she is, and that person doesn't have any identification. Basically, this measure is going to criminalize anyone without an ID at this time. And then the problem that we have with what form of ID are we talking about? In my written testimony, I do reference a U.S. Supreme Court case that addressed that problem. And then basically by criminalizing this, I think we're going to run into that problem as well. Otherwise, I'm available to questions later on. Thank you very much.
Yeah, thank you. Next up, we have DOT in support.
Mr. Chairman, members of the committee, the DOT is in support of the measure. In the interest of time, we'll stand on our testimony. Thank you.
Thank you. Next up, HPD in support.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Braden Ogata of the Honolulu Police Department, and I'm speaking in support of House Bill 1453 for the reasons stated in my written testimony. Just as a brief summary, when enforcing traffic code sections under HRS 291C, occasionally people will refuse to give officers their information in violation of Section 291C-172. Currently, violating this section by refusing to provide information requires officers to issue a citation. However, issuing a citation is not possible if the person will not give you their name. This is a functionality issue which this bill will correct by offering a progression of options to include arresting the offender for a petty misdemeanor if necessary. I'm available to answer any questions, and thank you all for the opportunity to testify.
Okay, thank you. Members, any questions?
Chair.
Report.
Captain Ogata.
Go ahead, sir.
Again, some numbers. That sounds like a good anecdote, but how often do people say, I mean, the first thing is when we get pulled over, we're supposed to roll down your window, give your driver's license without even ask for it, or insurance. How many people actually say, hey, look, I don't want you to know who I am or whatever? How often does that happen?
Let me kind of show it to you this way also. So 291C covers both driving offenses, also bicycle offenses, pedestrians. So this tends to be more of a problem for us when we're dealing with things that don't require a license. So to get you numbers, sir, first off, I tried to run for this particular section, 291C 172. In 2021, we found 6 times when a case was made for this. In 2020, I found 2 times. And I would suggest though too, that those numbers are probably misleading, because if you can picture it, if I'm stopping a person out there and they're refusing to provide any information, I'm going to have a hard time even generating a case. So that's, sorry, go ahead.
Mr. Ogata, the way I read the bill, it's saying that you got to provide identification. It doesn't say anything about information. It says identification, unless I'm misreading the bill.
No, it's either or. You just have to provide information so that you can identify the person.
It says refusal to provide identification is a petty misdemeanor. That's the only thing that this bill amends. So are you sure that if they didn't want to talk to you, if they gave you their driver's license, but they didn't want to talk to you, you still would arrest them? Because this bill just says they got to identify who they are.
I'm sorry, I missed that last one. So if they give you the driver's license, could you say that again, please?
If they give you the driver's license, but they won't talk to you.
No, that wouldn't be the case. So what's happening now is because it's an infraction, what happens is that people will just not say anything to you. This is common in my experience in jaywalking and this type. They won't even tell you who they are. They'll just try to walk away from you. So this would basically make that an arrestable offense. Because right now, if you try to stop them and they tell you they won't give you your name, there's no possibility to issue a citation. It's just not functional. We can't do it.
So you have no other way of, if they just get in their car, if they just start up their car and drive off, or they get on their bicycle and go away, there's nothing legally you guys can do it without this bill?
Oh, no, there are other things that can be done, but I'm trying to focus just simply on the simple violation of when they refuse to provide their information. In that particular case, we get stuck. We have to issue a citation. And if they just say, I'm not giving you my name, then we get stuck. And this is where this can correct that block for us.
Okay, if this one passes and they don't give you your name, now you've got this, what do you do with this one then?
You could potentially arrest them. So it's actually a better course of negotiation too. Obviously, we don't want to be arresting jaywalkers and that type of thing. The whole point is that if there's a clear structure for us to follow, then from there, once we can tell them, look, sir or ma'am, please just understand that this is arrestable if by chance you refuse to provide us any information. That can help us to basically just get a name, give a citation, and move on. So that's kind of what the problem is, sir.
This is another stick, if you will, then you could actually tell them that if they didn't give the information, they would do it. But it would seem as though even they gave you the, well, anyways, we got to help you guys do your job. It's really a trying situation, particularly when you're 200 to 300 officers.
Thank you, Representative.
Thank you, Mr. Gata, for your service. Thank you, Chair, Vice Chair.
Rep. McKelvey?
Yes, sorry, for the officer again. I'm looking at the bill and I'm a little confused because right now under the current statute, it says you shall provide the person's name and address or any proof thereof. And in the bill, you're taking out or and you're adding the word and. So under this bill, if it becomes law, you would have to provide your name and address and any proof, not or. So you're saying, well, we can't have them give us any information, but this thing would require them to give you their information and provide a proof of it. So if the pedestrian, say, is walking to the store and doesn't have a driver's license or a credit card or anything on them, right now you stop them, you can ask them their name and they can either give it to you or they could provide proof of who they are, which they wouldn't be able to do. But under this law, you stop that same person, they say, well, yeah, my name is John Smith, but they don't have any kind of identification or license or anything to prove that, then they would be in violation now of 291C-172.
I see.
So you see what I'm saying? It runs counter to what your I guess the intent behind the bill is, and could cause problems in my mind.
I see.
But, yeah.
And so the suggestion of going to the or, Representative?
Yeah, I would recommend maybe, or obviously chair and vice chair, will make the final dispensation, but I think that presents a problem, and maybe you want to consider keeping the original or in there. Because I see the or both stricken out afterwards, which I think gets to what you were saying, but that could cause a problem in my mind. But I just wanted to bring it up because it was confusing me a little bit. Thank you, sir. Appreciate it.
Thank you for that.
Members, any other questions? Otherwise, I've got a follow-up for Rep. McKelvey's question with Officer Ogata. If we do not require proof of their name or address, is it possible that you could end up issuing a citation incorrectly? Like if I jaywalk and then I say, hi, my name is Rep. McKelvey or Angus McKelvey, and here's my address. Can I give Angus a ticket? Is that a possible situation?
Yes, and that's a hard part for us too, because in some cases, some of these things might become warrants. So we want to really, do our best to be correct when we're stopping people and we're issuing these citations. Now, it can go either way, where they might outright not say, I'm not telling you anything. Or the other option is, yes, they could say their cousin's name or somebody else's name, and we would have trouble with that. We do have some checks and balances. We have our computers. We can try and do a quick search. But the better we can fix this particular problem, again, it shortens the amount of time. We can quickly tell them, look, this would be an arrest if you refuse to tell me, or perhaps we can kind of tell that name doesn't sound right. If they sometimes people do really say obnoxious names, like my name is Mickey Mouse or something way out there. I've had that happen on a few occasions. So if that were to happen, then we want to try and minimize that. And I think this is the way to do it, through negotiation and then making a quick check and minimizing the time that we actually detain people during a traffic violation stop.
Okay, thank you. Members, any further questions? Otherwise, let's move on to HB 2247, relating to operating a vehicle under the influence of an intoxicant. First up, Department of Transportation and support.
Mr. Chairman, Members of the committee, the DOT is in support of the measure, and in the interest of time, we would like to stand on our testimony. Thank you, sir.
Okay, thank you. Next up, Honolulu Prosecutors in support.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu on behalf of the Honolulu Prosecuting Attorney's Department. We'll stand on our testimony in support. Oh, there was a suggested amendment. I'm sorry, if we could add a definition for the term violation. Thank you.
Thank you. Next up, Smart Start LLC with comments.
Good afternoon, Chair, Vice Chair, members of the committee. Joanne Hamaji-Oto, Territory Operations Director for Smart Start LLC, Hawaii Corporate Office, offering comments to House Bill 2247 relating to operating a vehicle under the influence of intoxicant. In short, we ask that you amend the bill to include the compliance-based provisions of House Bill 1884 HD1. We have heard the concerns about House Bill 1884 HD1 and are open to revision so that it is only for those who have installed an ignition airlock to have a period of compliance to prove they are sober to drive. Thank you for the opportunity to provide testimony.
Thank you, members. Questions? If seeing none, we'll move on to HB 2344 HD1 relating to probation. First up, we have public defenders in support.
Hi, Chair, Vice Chair, members of the committee, good afternoon. I am Assistant Public Defender Lee Hayakawa. The Office of the Public Defender supports the intent of HB 2344 HD1. The OPD, however, has concerns about the HD1, which strip many of the tangible benefits that were offered to probationers in the original bill. In its original form, the measure had the potential to address issues of defendants being on probation too long and issues of overcrowding in Hawaii's jails and prisons. Our concerns are included in our written testimony. I will be available for questions. Thank you.
Thank you. Next up, we have the judiciary in support.
Good afternoon, Chair and Vice Chair. My name is Brooke Mamizuka. I'm the probation officer for Oahu. Written testimony is also provided by Craig Hirayasu from Maui, Dean Hiraki from the Big Island, and Renette Garma from Hawaii. The judiciary supports the criminal justice reform and supports House Bill 2344, House Draft 1, but would like to ask that review and early termination be conducted on all probation cases with the exception of cases involving habitual operating vehicle under the influence, possession of firearm, Chapter 134, domestic violence, violation of temporary restraining order and household and abuse of household members, 586-4, 586-11, and sexual assault and violence involving minors. These types of cases involve deceased victims and their families and/or victims that suffered physical and/or psychological trauma. In crimes of sexual nature, plea agreements often indicate that early termination cannot be considered. Some of these victims are receiving restitution while some while still on supervision. Thank you for the opportunity. I'm available for any questions. Thank you.
Thank you. Next up, Honolulu Prosecutors with comments.
Thank you, Chair, Vice Chair, members of the committees. Deputy Prosecutor Tricia Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Department, will stand on a written testimony, submitting comments. Available for questions, if any.
Thank you. Next up, ACLU with in support.
Aloha, Chair Nakashima, Vice Chair Matsuyoshi, members of the committee, Carrie-Ann Shirota on behalf of the ACLU. We submit comments in support of 82344 HD1 with the addition, incorporation of amendments. As the public defender mentioned, the reforms that were outlined in the original draft were essentially gutted by HD1. And I think we need to take a step back and look at the landscape. What is the purpose for this bill? The bill is to perpetuate or advance reforms within our probation system. And I've heard some of you discuss the importance of empirical data today, and we've done our best to collate that information for you in our testimony, and I'd like to highlight some of that. Within our probation system, this is from the Pew report, which was done in 2020, Hawaii ranks #1 as having the longest average probation term in months at 59 months. This is nationwide, #1. If you look at other data that comes from the judiciary and from other task force and reports, there is a high rate of probation revocations, in particular for Native Hawaiians. So there is a disproportionate impact upon Native Hawaiians in the criminal justice system, particularly within probation and revocations. If we need to go back to one of our fundamental principles of equal justice, we need to address that. The recidivism rates also within probation are high, averaging 54% based upon a 2016 survey. Why should we invest in these changes and reforms and limiting revocations? Essentially, if someone misses an appointment or maybe multiple appointments with the probation officer, or they have a relapse, which often may be the case, we understand that the judiciary needs to have tools to address that in terms of different types of provision sanctions. But we believe strongly that the response is not to incarcerate people. That should be the absolutely default and the last resort. And what happens is we see, if you look at some of the numbers, statistically, it may seem small, but in 1 year alone, this is based upon 2020, 21, there were 495 persons on probation who had technical revocations. When you times that by the amount that we spend on incarceration, $219 a day, that amounts to $39 million per year. We could have an incentive-based system, whereas if people comply with the conditions of probation, for example, 30 days compliance, 30 days shaved off of their term, as it has been done in other states. And they've seen positive outcomes where there is an incentive to comply with the conditions of probation, and we're not throwing the hammer at people, removing them from the community, from their families, potentially terminating parental rights, losing their jobs, a whole host of other progress they may have made in the community. Please
that's been 2 minutes. Could you please conclude your testimony?
Yes, so we ask that to make significant reform in our probation system, which again has the longest sentences in the United States. You can safely reduce technical violations and have a good time earned credit, and also achieve and promote community safety. Thank you.
Okay, thank you, members. We have a number of individuals submitting testimony as well, about 10 in support, 1 in opposition. First up, we have Lauren Tajiron in support.
Hi, everyone. My name is Lauren Tyron. I actually have a friend who is trying to testify as well, who submitted testimony days ago, but he did not receive the Zoom link. John Mickey, if he would be able to go after me, or if you guys would consider him to testify at some point, that would be great. Again, thank you for letting me speak today. My name is Lauren Tyron, and I come here today to show my support for HB 2344. I come not only as a political science student who studies the ways in which Native Hawaiians are suffering from the illegal occupation of their islands, and how that illegal occupation has led to the imprisonment population being 40% Native Hawaiian and Pacific Islander. But I come here first as a person of Oceania, a sister to my Kanaka Maoli siblings, and most importantly, as someone that recognizes that it is not these people on probation who are at fault for not being able to exit this cycle of incarceration. It is the system that works against them. It is the system that displaced them, that kept them from being fed, from being loved, from being employed, from in touch with their land and culture. And it is the same system that tells them to get a job and to be a better person and to make something of themselves, but refuses to provide any assistance in doing so. Instead, the system presents obstacles in the form of technical violations. Representatives, I ask you to recognize how many times these people have been told to just get it together. I ask you to recognize how many times they have been turned away, how many times services and other necessary resources have not been available to them. I ask you, how do you expect them to do this when it seems quite literally impossible? When I look at these bills in their current state, I see a future in which we can realize that these people are not bad people, but the victims of a bad system. In these bills, I see a starting point for our friends and family who are trying their hardest to get out of the cycle. And I see a future for our children, that given the high likelihood of them entering the incarceration system, that there actually might be a way out. Again, my name is Lauren Tyron, and I support and ask that you vote yes on HB 2344. I also ask that you consider reverting it back to its original form. Thank you, representatives, for letting me speak today.
Okay, thank you. And Lauren, we do not have John's testimony, but if you'd like to have 2 minutes to speak now, we can do so if he's with you.
Yes,
okay.
hi, thank
Go ahead,
you.
John.
Thank you, Vice Chair, and thank you for providing me with this opportunity to speak. I'm here to speak on behalf of my support for HB 2344, specifically to the version of HB 2344 that was prior to it being gutted to its current state, which is now HB 2344 HD1. Primarily, I'd like to touch on some numbers because I feel like that's something that has not been talked about enough. As of January 31st of this year, that's January 31st, 2022, Hawaii jails and prisons currently hold 1,028 people due to probation or parole revocations. For reference, that's a quarter of the incarcerated population here in the state. And what I'd like, and I'll keep this short, is what I'd like representatives here to consider is that when nearly a quarter of your incarcerated population is there because the state's probationary program failed to help them get through that system, I think it becomes really clear that this is not a matter of people not wanting to get out of parole, but rather that our parole system is not helping these people rehabilitate back into our society. There is no reason that rehabilitation and treatment shouldn't come to those who need it outside of prison. And I feel that a lot of the narrative at this moment is misleading you to believe that prison and rehabilitation are synonymous, which is far from the case. So thank you. Please fix the system and support HB 2344. I'm asking that HB 2344 be reverted back to its original position. Thank you.
Thank you. Next up, we have Nicole Roten in support. Not present. Next up, we have Peter George in support.
George, yeah, no problem. Yeah, thanks for letting me speak today. I just want to voice my support for HB 2344 under the condition that the bill be returned to its original form. I believe that we need to end incarceration for technical violations of probation, create a good time credit system for reduction of probation terms, and prohibit the imposition of certain unreasonable probation conditions. What's happening right now doesn't benefit anyone on any level of the system. We can think about how the state's jails and prisons are so overfilled that there's an active debate about whether we should spend $1 billion on a new jail, while at the same time, roughly a quarter of jail and prison admissions in Hawaii each week are the result of parole and probation infractions. With the original set of provisions, HB 2344 is a no-brainer when we consider the deplorable conditions of the state's facilities and the dire need to get people out of them. And then the next question there naturally is, okay, well, what are the consequences? Answering that question means referring to the best available data rather than our intuitions or conventional wisdom. There is no evidence that incarcerating people for non-criminal probation infractions improves public safety. And additionally, the cities and states that have already taken this and other measures to decarcerate haven't seen associated spikes in crime, but they have helped support communities that face the most dire circumstances. And, I think in full form, this bill will support communities that have been beaten down and traumatized the most by our society, people who just want to live in peace, comfort, and stability like the rest of us. So passing the original version of HB 2344, I think would be an important step down a long road that our government needs to walk as it pursues justice. So thank you all for allowing me to testify today.
Okay, thank you, members. Any questions? Okay, seeing none, we'll move on to HB 2113 HD1 relating to money transfers. We have one testifier today, DCCA, in support.
Aloha, my name is Iris Ikeda. I am the Commissioner of the Division of Financial Institutions, testifying on behalf of the Department of Commerce and Consumer Affairs. So the purpose of this bill is to minimize regulatory burden and eliminate the redundancy by permitting money transmitter applicants to submit either a state or federal criminal background check rather than both. And I will be happy to answer any questions if you have any.
Okay, thank you. Members, any questions?
Quick question, Chair. Yeah, sorry. For Iris. Iris, wouldn't there be things that that would show up on a federal criminal background check that might not show up on a state one, and vice versa?
Yeah, so we have been running a parallel system for the last 7 years. when the state became a reporter to the national database. And we have not found any disqualifying discrepancies between the state and the federal criminal background checks.
Okay. All right. Thanks for the edification. Appreciate it. Thanks, Vice Chair.
Good question. Members, any other questions? Okay, hearing none, we'll move on to HB 1455 relating to robbery in the first degree. First up, we have HPD in support.
Good afternoon, Chair, Vice Chair, and members of the committee. I'm Brandon Nakasato. The HPD will stand on our testimony in support. Thank you.
Okay, thank you. Next up, we have an individual, Michael Rice, in support.
Aloha. Yes, I stand in support of this bill. I believe that these sort of laws are what we need to help prevent, well, not prevent, but prosecute attacks against individuals who would misuse tasers. I fully support this kind of law, and as opposed to, for example, HB 1732, which is being held shortly, as it actually targets the individual who would break the law rather than everybody. Other than that, I stand on my testimony.
Okay, thank you. Next up, we have Marcus Tanaka in support.
Yeah, I support. Thank you.
Okay, thank you. That's all the testifiers. Members, any questions? If seeing none, we'll move on to HB 2213 related to mail theft. We've got one testifier today, AG's office, with comments.
Good afternoon, Chair Nakashima and members of the committee. Lauren Nakamura, Deputy Attorney General. The Department of the Attorney General strongly supports HB 2213 and respectfully requests that the amendments proposed in our written testimony be adopted by the committee to improve both clarity as well as to maintain consistency with the remainder of the Hawaii Penal Code. Thank you for the opportunity to testify, and I'm available for questions. Thank you.
Okay, thank you. Members, questions?
Quick question, Chair, or Vice Chair.
Shelby.
For AG's office, you're still there.
Yes, I am.
Don't we have a federal statutes against mail theft that are?
Yes, we do. There is a federal statute regarding mail theft, particularly which was, I guess, most highlighted in the recent federal trials of certain individuals. However, what this bill will do was it will create a specific one that is enforceable within the state itself from the state prosecution point of view. We don't have anything similar in our current statutes that would allow mail theft based on the circumstances that is the intent behind the bill, which is to address mail theft of particularly packages left at doors, as well as actually out of our mailboxes.
But wouldn't, I mean, the mail system is a federal system. I mean, shouldn't the federal laws against mail thefts suffice since it's basically a federal entity and a federal program?
The jurisdiction of the federal government comes from the fact that mail comes from different states and crosses jurisdictional lines. This in particular will cover situations in which our Hawaii residents are the recipients of mail and have already been received or are in the process of being received. Yes, the federal government could pursue the same type of crime under the federal statute, but if, say, we do in the situation have a successful state prosecution of this statute, there would be considerations made on both federal and state side regarding double jeopardy, which would prevent dual prosecutions in that particular situation.
Okay, so just to clarify, so if somebody sends something from, say, Maui to Honolulu intrastate, then the feds wouldn't necessarily be able to go after it, even though it's using the Federal Postal Service as the conduit.
No, what I'm saying, I believe that the federal government would be able to. However, the intent of this bill is to allow for state prosecutors to pursue a similar type of crime, while also not preventing the feds from pursuing their crimes that they so choose to pursue.
Okay, thank you for that. I still am a little confused as to why the federal law wouldn't suffice, but thank you, Vice Chair. Appreciate the question.
Members, any other questions?
I have a question. Chair.
Report.
Thank you, Chair. Lauren, my wife is a big Amazon shopper. If somebody, at least once a week anyway, if someone takes her package, does this bill cover that? Or is it covered by the one you already said?
In the situation you're outlining, yes, this bill would absolutely cover that. The key point here is with respect to the ability for us as the state prosecutors to pursue crimes in which mail is taken, not only from mailboxes, but from the premises of the particular addressee. So in your situation that you outlined, yes, if someone were to come onto your property or take property left by Amazon for your wife, yes, this bill would absolutely be able to cover that.
So if someone comes on and takes her Amazon, there's nothing in the statute that you could use, but you need this one in order to do something if they take her Amazon package.
Yes, I guess most simply, yes. There
Okay.
is, I guess, some arguments that could potentially be made for another statute, but that is in a very narrow situation in which would involve the confidential personal information. So it would depend on if your package contains something that would fall under the confidential personal information.
The online shopping now is like 30-40% available. And
Yes.
my wife didn't tell me to ask this, but she was going to ask me after this hearing anyway. Thank you.
You're welcome.
Sure.
Thank you,
I have a-
members. Any
Yeah, Vice Chair.
questions?
Yes, I have a question.
Sorry, I can't tell who's speaking.
This is Rep. Tokioka.
Okay, yeah, Rep. Tokioka, go ahead.
Yes, and this is for Ms. Nakamura. So
Yes.
to just follow up on Rep. McKelvey's question and Rep. Ward's question, can you draw us a picture and explain, because I'm still kind of confused as to why the federal statute doesn't kick in or supersede anything that we're going to do and would not allow you folks to do something. So can you draw us a picture of a crime that happened and how us passing this bill would help you prosecute the person?
Sure. In a situation like the one raised by Representative Ward, say the package was delivered by the United States Postal Service. In that situation, particularly, the federal government could pursue federal prosecution based on the federal statute. However, say that same package had instead been delivered by common carriers like FedEx, the federal statute would not cover that situation. It is the use of the United States Postal Service with a combination of crossing state lines that allows the federal statute to be used in those types of prosecutions.
So it would just cover FedEx and UPS. I mean, yeah, not the United Postal Service, but
UPS, not USPS.
UPS. Yeah, UPS.
Yes, which is
Okay.
why we try to define it as common carriers of mail.
Okay, thank you. Thank you, Vice Chair.
I have a bit of a follow-up to that, Lauren. You're saying that you can't go after someone who steals an Amazon package, but surely you can still go after them for some kind of theft that is already under the statutes. Isn't that correct?
Yes.
Maybe not theft too.
Yes, the issue with that in particular is with respect to the theft charge. By virtue of the way the statute is written under theft, the prosecution is required to establish a certain value amount in order to determine the degree of charge. So, for example, theft in the first degree is $20,000 or more. I think theft in the second is $750.
Yeah.
In the theft statute proposed here for mail theft, that additional element of establishing a value is not necessary to be proved. It is merely that the common carrier delivery service attempted to or delivered or.
Right. I understand it. It would
Yeah.
certainly make it easier for you folks to pursue them on a higher charge. But what I'm saying is, surely you can still prosecute them for theft 3 or something if someone stole a package from your doorstep. Isn't that correct?
Yes, we would have to. We
And
could
then proving the
potentially
value,
do
I
that.
can't think of something easier to prove the value of than a package from Amazon. You could literally print out the invoice. So establishing the value of a brand new item from Amazon being delivered that you just paid for, I would think that'd be fairly easy to establish. I'm not sure that that's necessarily a barrier for pursuing a theft charge from a box delivered by Amazon. So can you still, if someone steals Rep. Ward's wife's Amazon box, or my wife, who is more of a once a day Amazon shopper, if someone steals one of the boxes, can you still prosecute that person without this statute?
We can prosecute it technically under a theft statute. However, what the intent of this particular statute is to prosecute situations in which maybe it's not an Amazon package, but a letter of importance that may not have a specific value. In the circumstances where we cannot prove a specific value, it becomes a theft in the fourth degree, which is may not accurately reflect the severity of the information or the contents of that particular package.
Understandable, but this is theft too, which is fairly high. And anyway, we can agree to disagree on that. Thank you for answering my questions. Members, any other questions?
Chair, follow up. Nakamura, I'm confused. On the one hand, we need it. On the other hand, we don't need it. Is there a way you can simplify the difference here? Is it because the common carriers in their value or in the present statute, you have to run through or loop more hoops in the existing statute, and this is facilitated?
Yes, essentially what I may have not articulated well is that in a situation of when we pursue theft prosecutions, the state is required to prove that the defendant at the time of the taking knew the value of that item. In the situation that is attempted to be covered by this proposed statute, that additional element is not required. It is merely that they are not the addressee. It was taken from the premises. It was delivered by either a common carrier or any other delivery service, or in the alternative, left for a common carrier delivery service to deliver to another person.
Thank you for that clarification. That does make it much clearer. Thank you, Chair.
Members, any other questions?
Vice Chair, just one quick follow-up.
Yeah. Go ahead, Rebecca.
So AG, so it would have to be a common carrier. It couldn't be like, say, flyers or something like that wouldn't be included.
I'm sorry, I don't quite understand.
Like say somebody hand delivers a letter, like, our neighbor down the street, when the new neighbor moved in, they hand delivered a letter to them and it was taken. This wouldn't apply. This wouldn't cover the situation, even though because they're not a common carrier.
Yes, under the statute, that is, if like say a neighbor left a letter in an envelope for you, this statute would not cover that particular situation.
Yeah, so, okay. Thank you for clarification.
Again, sorry, I have one more question now that I'm reading the theft 2 statute. I don't see the mens rea as having to be thinking you're stealing something of a value that exceeds a certain amount, just that you're stealing something and the actus reus is the value exceeds a certain amount. Are you sure that the intent needs to be to steal an item of a certain amount? I just don't see that reflected in statute.
It's not reflected necessarily in the language of the statute. However, it is a precedent set by our case law.
Okay. Members, any other questions? Okay, if not, let's move on to HB 1732, and this is on the proposed HD1, which is posted online, relating to electric guns. As you can imagine, we have a lot of testimony on this bill. First up, we have Department of Transportation in support.
Mr. Chairman, members of the committee, the Department of Transportation is in support of the measure, and in the interest of time, we would like to stand on our testimony. Thank you very much.
Okay, thank you. Next up, HPD in opposition.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and the committee. Again, I'm Major Joseph Trinidad Home Police Department, and we stand by written testimony in opposition of this bill, and I'm available for any questions. Thank you.
Okay, thank you. Next up, we have a number of individuals testifying in opposition. First up, we have Andrew Roberts in opposition.
Hi, good morning, Chair, Vice Chair. My name is Andrew Namiki Roberts. I am the plaintiff in the lawsuit that was filed in 2018 to overturn Hawaii's ban on possession of tasers. I would like to first point out that the Attorney General is very missing from this hearing right now and didn't submit written testimony. And the reason behind that is because we have an open lawsuit on this. My lawsuit is not done. And if they testified in support of this bill, it would be contradictory to a brief that they filed with the Ninth Circuit Court of Appeals in regarding to this lawsuit. And in that, they said nothing in Act 183, which is now HRS 134-81+, limits the carrying or possessing of electric guns in specific locations. The primary limitation on the use of electric guns is that they must be used for self-defense of yourself, another person, or protection of property, which can occur anywhere. The HRS 13481 contains no provision that is the equivalent of place to keep or carry requirements, which limit the possession of a firearm to a person's place of business, etc. So Act 183 clearly permits you to carry or possess electric guns regardless of the location. The Attorney General has written a brief to the Ninth Circuit making it very clear that the intent of this law is to allow people of Hawaii to carry a taser or an electric weapon for self-defense. They admitted that these are not deadly, they are not dangerous, they are a self-defense tool that are a single shot device. They're incapable of causing mass casualties or harm to many people, and in fact are less dangerous than other implements that someone might carry, such as a knife, machete, or a screwdriver. All of which could be very harmful. If this law is passed, it serves no purpose. It's already a misdemeanor to use one outside of self-defense, and it's a felony to use one of a crime. This is an add-on crime to something that would be hard to discover. A person could hide a taser about their person and never be found with it. The only thing that this law will do is discourage people of Hawaii from carrying a taser or an electric gun for self-defense in places such as on the bus, traveling to and from work. And if they're a government worker, which 30% of our population work for the state, city, and county governments, it would dissuade them or prohibit them from being able to carry an electric gun on their journey to and from work or throughout the rest of their day after work while doing it so. So that's 30% of your own employees that you're now prohibiting from carrying a tool that is a single shot device for
Mr. Robert, that's been almost 3 minutes. If you could conclude your testimony.
I appreciate the time, Chair, Vice Chair. Thank you very much.
Thank you. We've actually got a couple of institutions. Mr. Roberts, you must have been important enough to be included among them. First up, we have DC Project Hawaii in opposition.
Aloha, thank you for the opportunity to testify today. I will stand on my written testimony, and I just wanted to highlight how this bill would affect me personally and my family. My husband is a firefighter, so he works on city grounds. My oldest son rides the bus to work, and I drop my middle son off at school every day. So if this bill passes, none of us would be able to carry a taser for self-protection on a daily basis because we all visit the places that this bill would ban. Another point that I forgot to include in my written testimony is that the places where this bill proposes that tasers be banned, these are the places that a lot of homeless and mentally ill members of our community tend to frequent and congregate. Our homeless and mentally ill tend to commit a significant portion of attacks in Hawaii. As I mentioned in my written testimony, I and two children that were with me were attacked by a mentally ill man near a bus stop. And if tasers were legal at the time of the attack, I could have used one to defend myself and the kids. Thank you.
Thank you. Next up, we have the Pu'uloa Rifle and Pistol Club in opposition. Not present. Next up, Michael Rice in opposition.
Well, I'm standing in opposition to this bill. This just needs to be killed outright. As others have mentioned, it would prevent people who take the bus, such as myself, from being able to carry a taser to defend myself. And we've seen numerous attacks on buses, sexual assaults. Literally, someone was attacked with a hatchet on board the bus, and no charges were pressed against them because they just didn't want to deal with the hassle. And I would also ask, how many of your staff, how many of you take the bus every day? Now that you have, or how many people do you plan on taking the bus, taking the train, whatever? Not all those people can no longer carry a taser throughout their day because they can't have it on the bus, can't have it on the train, can't have it near any the prohibited locations, as you call them. I apologize, I'm having a moment. And it's just, now you're just restricting all these people from being able to defend themselves with a right they just got back. And is currently not even really feasible for most people to get, because you still can't buy a taser right now because nobody is approved to sell one. And this would also discourage, like right now, I currently drive everywhere due to COVID. I'd much prefer to catch the bus or the train once it's ready. Once this bill is, if this bill should come to pass, I will not be considering taking any form of public transit, since that will reduce my capability to defend myself or potentially others in such a situation. Thank you all. I yield the rest of my time.
Okay, thank you. Next up, we have Rosemary Jouch in opposition. Not present. Next
Yeah,
up,
no,
Cheryl.
I'm here.
Oh, sorry, you just have a phone number, not a name. Go ahead.
Okay. Well, thank you for allowing my testimony. I did submit written testimony. I stand on that. I have defended myself with a taser. I'm 64 years old. I cannot carry a handgun in this state. And by limiting my ability to carry my taser in your prohibited locations, you're putting me at risk. I'm entitled to defend myself. I hope that this bill does not go any further. Tasers are non-lethal options. And one of your prohibited locations is a police department. I'm sure you're all very well aware that a woman was just bludgeoned to death with a log on the steps of the police department. I yield my time.
Thank you. Next up, we have Cheryl Tanaka in opposition. Cheryl, you're muted. Is she able to unmute? Cheryl, if there's a option popping up to unmute yourself, please press that. Okay, we're going to come back to her. Ryan Tinajero in opposition.
Representatives of the Judiciary and Hawaiian Affairs Committee, I stand on my written testimony in opposition to HB 7032 HD1 because it actually serves as a direct prohibition against health and safety. By restricting locations where your constituents can really defend themselves with a defensive electrical device such as a taser, you are essentially telling us that our lives don't matter. Case in point, by making the possession of a defensive electrical device a misdemeanor in various public locations throughout the state, you make any effective defensive use of such a device a crime. As you've already seen in the news, there are attacks on your constituents and on buses, in public places, in public government facilities. And it turns out just calling 911 isn't always feasible in those situations. I don't think the rest of your constituents are okay with such ongoing threats of violence. Do your constituents a favor by voting against HB 7032 HD1 in order to let your constituents know that you actually care about their safety, wherever they may be. I'm available for any questions or comments. Thank you for your time.
Okay, thank you. And I see Cheryl Tanaka popping in and out. Cheryl, is your microphone working now?
Yes, I think so. Sorry.
Okay, yep, please go ahead.
Okay, so excuse me, I'm a little emotional right now, but so I used to live in Chinatown in a low income housing where I had to walk by the homeless shelter and soup kitchen every day to get to the bus stop and college and work. I had a few instances where I had guy rubbing my leg on the bus multiple times. I tried to like move to another seat. They kept following me until I just kept standing because I didn't feel safe. And then I had a druggie one time follow me off the bus, stopped me in the middle of the crosswalk, grabbed my arm, and I just ran home. And then, so ever since that, I was too scared to go to the bus and ride the bus. I had to beg my parents to buy me a car because I didn't want to skip school. And then I had to use all my savings so I could go to school because I didn't feel safe anymore. And I almost got kidnapped before multiple times. This is not the first time I ran into incidents. Well, I was in the UH parking lot in the middle of the day. I had a man follow me to my car. So this is scary because a lot of us students, because we have a 24-hour library and a lot of us study till like midnight, 1 a.m. Imagine how more scary this is. And I'm sure there's a lot of rapes happening on the campus. And then not only that, mothers or like me, I'm going to hopefully in the future, I'll be a mother, but mothers who are picking up and dropping off their kids to school won't be able to be on school campus watching their kids go to class safely. They have to go across the street. What if, their kids get run over now because of stupid stuff like this, And then when I was working for the state, that's also another issue. I've got groped a couple of times while working in the middle of the daylight. So how do you think this bill is going to prevent me from caring from all these situations? It just sucks. And I strongly oppose this bill. I forgot to tell you that.
Thank you. Thank you for your testimony. Next up, we have Mitchell Weber in opposition. Not present. Next up, Stephen Kumasaka in opposition. Not present. Next up, Marcus Tanaka in opposition.
Hello? Hello?
Yep, go ahead.
Okay, so I was reading over all the testimony and you had one department support this bill and about 140 people oppose it. So, your guys' job as the reps are to do what the people want. That's your job, is to represent the people. So in a situation like this, it's almost a unanimous opposition to this bill. So I feel like this bill shouldn't be going any further than this committee because only one department supported it. Everyone else opposed it. Okay. And the other thing is, everyone mentions, that woman at the police station at Kapolei. Well, a bunch of me and my friends were outside of the Beretania police station. This crazy guy walks up to us about 7 o'clock at night and starts yelling at us, swearing at us. And, there's 5 of us there. What if that was a female by herself on the steps of the police station? That's where we were, on the steps. There wasn't any officer who come out to see if we needed assistance till after the person left, about 30 seconds later, once the guy left. And he was yelling at us for maybe another 30 seconds, maybe a minute tops. But, this bill would prevent someone who is going to the police station for a purpose in a non-secured area to have their taser, say they're there to register a firearm. They already have a firearm in their gun case, but now they can't have a taser. And if they're parking in the public parking lot, they can't, leave their taser in the car, which is irresponsible, by the way, but that's beside the point. Point is, they're gonna have to leave everything at home, pretty much. So, I oppose this bill. Thank you.
Okay, next up, we have Joshua Yamashiro in opposition. Okay, not present. Todd Yukutake in opposition.
Aloha, Judiciary Committee, Todd Yukutake, and I oppose HB 1732. I work as an armed security officer at the federal building. So I basically work the checkpoints and do patrols, things like that with a handgun. But over there, electric guns are prohibited, and I have to turn people away who need services there because they have pepper spray, knives, other stuff. But I feel bad for them when I do that because I know there's a lot of homeless, crazies, drug addicts all over the place there. We deal with them all the time. They break things, they yell at people, attack people, and I feel sorry for them because I leave them defenseless. Even myself, I have to walk a half mile to my car in Kaka'ako late at night, and I feel afraid too myself. Another thing is some of these people, they'll just throw their items into the trash can or into the bushes outside. So if they have an electric gun, they would throw it into a trash can or bushes and someone else would take it. And like I said before, people on buses, we have a lot of low income people who catch the bus. They'd be defenseless going to a federal building or other state buildings. And this bill also doesn't work for local government buildings because you don't have armed security or x-ray machines, screening checkpoints. Basically, criminals can just bring in their weapons to, on grounds or inside of the buildings, while good people like me cannot because we follow the law. So this law does not work. Criminal, let's see. Of course, like they said before, crime happens anywhere. Kapolei murder. Even at the state capitol, there was that sheriff's deputy that got attacked one night. Or across the street at Department of Health, there was that was a pruning shears incident. A guy with pruning shears, I guess, threatened people, and then police went there and shot him a few years ago. So crimes can happen anywhere. So please allow people to protect themselves with electric guns anywhere, and please oppose this bill. Mahalo.
Thank you. Next up, we have Jason Renaud in opposition.
Good evening, everyone. My name is Jason. I thought this bill was really important to speak up and say something. I've never been involved in any kind of testimony whatsoever, but it was very important for me to share. I submitted my testimony and I stand in opposition of this. Like Marcus was speaking about a few minutes ago, just look at the difference. Just take all of the testimonies into consideration, and you can pretty much look at the outcome of what the people want. But thank you guys for this opportunity. Hello.
Thank you, members. That's all the testifiers we have here today. Any questions, members? Report.
Thank you, Chair. Is Mr. Roberts, the first testifier, still around? Mr. Roberts, the one who had the charge. Okay, if not, HPD or ACLU or DOT, are you guys still here?
Representative Ward. Oh,
okay. Again, I'm trying to mine, Mr. Trinidad. HPD, good. I'm trying to mine some data as usual. What is the geography of crime? In other words, where do most criminal acts that are violent take place? Is it in the household? Is it in the streets? Is it in the retail places? Give me the allocations of where crime predominates. Let's say the top 3 places.
You're asking a very general question, sir.
Okay.
You can hear some of the testimonies. Crime can occur everywhere, sir.
So we don't have any geographers on crime. I mean,
we have geographers. Well, hold on, sir. I can get you the information, sir. We have the information, but at this time, I do not have the information. I can get it to you, sir.
Oh, okay. Thank you. I'd appreciate that because
yes, sir.
It's really a very geographical specific. Mr. Roberts, is that you or is that somebody else with your beard?
I am here. Sorry, I couldn't get my mic to unmute.
Oh, okay. You are. Given the testimony and given the words in the bill, where can you carry your taser?
So if this bill was to pass, it's more exclusionary as there when you can carry it. Some of the places in the bill are very specific, such as Iolani Palace, libraries, government buildings such as the Department of Health. Those buildings are very concerning to us because that's places that you would commonly go. There's not a lot of crime at these places, and the crime that does occur, it's usually homeless people or people that are on drugs that are attacking either customers or employees. It's very concerning to see the list of places, including being able to ride the bus. It's just a very concerning list, and there's no rhyme or reason for it. So if you look at the crime statistics in other states where tasers are used in crimes, they're very, very rarely used. I mean, this is a $400 device that's a single shot taser. I've been carrying this now for almost 2 months. I've been to public buildings, I've been to HPD's main station, I've been to the Capitol, and nobody's had any problems with it. And I'm carrying it openly everywhere I go and everywhere I can legally take it. We've not had any issues. No retail establishments have had problems with it. There's not been any confrontation over it. Most people are just asking me where they can get one, which we can't do right now. So it's just concerning that it is restricting these places that you would commonly go, and it will affect everybody's day-to-day life.
So you cannot buy a taser in Hawaii yet. So it's only what, mail order that this is happening, or what?
So right now you can't even buy them online because the counties are refusing to comply with the law and issue licenses to dealers. There's a lot of back and forth with that, and I mean, I don't want to get off track with this bill.
Yeah, I was going to say that we're getting a little off track.
Okay.
Right in the state.
I'm trying to narrow down what this sounds like, a preemptive strike, if you will. If it's a bill for something that people don't even have yet, which they can't carry to a place that doesn't exist yet. Okay, thank you, Mr. Roberts. And Mr. Trinidad, you're going to give me the data. HPD is going to show me the geography of crime.
Yeah,
Yes, sir.
Trinidad,
Yeah, we actually have.
Thank you.
You send that
Yes,
to
sir.
Chair Nakashima, and then he can distribute it to the entire committee.
Terrific.
Yes, sir.
Appreciate it.
Thank you. Rep. Presti.
Thank you. For HPD,
Go ahead, sir.
in looking at your testimony, it seems like the main opposition is the lack of clarification about measurable distance, which I
Yes,
can
sir.
see why that would be an issue. Is if that were somehow satisfied, are you guys then in favor of this or opposed to it?
We can relook at it, sir. Well, we're going to run through our legal. I'm not going to give you an answer right now, sir.
I see.
But we can relook at it. But again, the way it reads right now, in or near, that's unenforceable. Again, police officers, we're human beings. That is subject to multiple interpretations, sir. And we don't
And
want
what
to be
about-
liable for that, sir.
Thank you, officer. And then what about if it was language amended to say I wanted to carry one, but I can't take it in the building, but I could keep it in my car? Or is that? I don't know how the statute's written for, say, firearms, not firearms, for other kinds of items. Is
Well,
that
first-
something that's amendable?
Yeah, anything's amendable, sir, but
Well, I mean, go ahead.
we'll just we'll review it. We'll relook at it. Again, we'll pass it through our legal and the subject matter experts in our department. We will always relook at stuff, sir, if there's amendments. Again, there was an amendment to this one, the HD1, but the again, in or near is still in the bill.
Yeah.
And that's where we have an issue with, sir.
All right. Well, and I just wanted to say for the record, I see some problems with this too. And at the moment I'm opposed to it because I would want to carry one. And I want my staff to carry one because I've had staff assaulted near the Capitol.
Yes, sir.
I've been assaulted or attempted mugging outside the police station in Chinatown. My wife and I, a couple of years ago, we were right
Sorry to
next
hear
to the
that,
police
sir.
station.
Oh, boy.
And the guy followed us into the police station.
Is there a question?
No, I'm simply stating for the public to say I'm opposed to this. Thank you.
Sure.
Thank you. Members, any other questions? If not, we'll move on to HB 2380 relating to firearms. First up, we have the AG's office in support.
Good afternoon, Chair Nakashima and members of the committee. My name is Amy Murakami, representing the Department of the Attorney General, who strongly supports this bill, which would create or allow the department to create a statewide program that's responsible for issuing firearm qualifications, credentials for qualified retired law enforcement officers pursuant to the Federal Law Enforcement Officers Safety Act of 2004, commonly known as LEOSA. This would give the department the statutory authority to run the program as well as to promulgate rules to ensure that retired law enforcement officers are properly certified under the federal law to carry a concealed firearm. I'm available for questions. Thank you.
Thank you. Next up, we have Michael Kitchens in support.
Hello, Chair, Vice Chair, and committee members. I am actually a card-carrying LEOSA retired law enforcement officer for the military. I'm actually a former combat arms instructor as well. I've trained quite literally thousands of people in the art of, handling weapons and to do it safely. And yet, because of the hindrance and the the way the current state implements the law here, I'm not able to actually carry a weapon, even though I've been authorized already to do so. And that, I think that's really unfortunate, because this type of hindrance for people who have basically served, some who have served much longer than I have, both in a law enforcement position as well as a military law enforcement position, I think it's a real, it's really a slap in the face to them. I mean, these people put their life on the line for years, that are currently still putting their life on the line for years. And just because they're either coming out of state or because they're retired, they're unable to carry. So I think it's very important that this is that LEOSA card carriers are given the right to do that. So that's my testimony, and I stand on it. Thank you.
Thank you, members. Any questions?
Chair,
Yep, Rep. Lopresti.
for the Attorney General. Why doesn't this create a double standard for regular citizens?
This is a federal law, Representative Lopresti. So the federal government created a statute that permits law enforcement officers who meet certain qualifications to carry a concealed weapon. And under the federal law, the requirement is that they have to be annually certified. They have to meet a firearm qualification standard. That they left that to the states to establish what that standard is and to issue certifications in certain situations where the retired law enforcement agency is not willing to do the firearm certification for the retired personnel. So we are merely trying to give effect to a federal law.
Well, I suppose my question is more philosophical than even at the federal level, because some states treat this issue differently. Some prohibit concealed carry, or at least in practice. And this would allow some citizens to carry them and others to not carry them. Is there, am I missing something that's a double standard?
I'm so sorry, Representative. I don't think that's something I am.
That's okay. Sometimes I have to ask questions to make it look like, I have to make a statement, but make it look like a question. So thank you. Thank you, Vice Chair.
Okay, Rep. Nakamura.
Thank you, Chair. I have a question for the Attorney General. I'm not clear in reading this bill whether some officers may retire from the force under a cloud or negative circumstances, and is that taken into account? I'm not seeing that in your criteria.
It is part of the federal law. So under the federal law, they have certain standards that must, or qualifications that must be met before they are considered to be LEOSA and covered by the federal law. And one of those things is that they must separate from their agency in good standing.
Okay, good. Thank you.
And sorry, I just have a follow-up to that while we're on that. And under RIOSA, is it also, if the officer is has any kind of violation dealing with firearms, would they also be disqualified from this if they're retired?
Depends on what the violation is. So if the person, I mean, obviously, if the person is not qualified to be able to carry a firearm under state law or federal law, then they would not qualify for LEOSA. If there were violations that would, basically, I guess if your question is if there were violations that would prohibit them from carrying a firearm, that would also prohibit them from carrying under LEOSA. So
that's fair enough. Rep. Lowen?
For the Attorney General also, is this an administrative package bill?
This particular bill is not. There is one that was part of the governor's package.
Okay, and if we never pass this, you're currently, I guess it's required to pass this law to be able to allow these retired officers to carry guns. So because there's a federal law, if we take no action and then these officers can't carry guns, are we running afoul of federal law somehow? Or is that a choice they left it to the states to be allowed to make it? That's part one of my question. And part two is, what have other states done? Is every state like authorizing this, or are some states not?
So there's a multitude of ways that this law can be given effect. One is that when the agency that the officer retires from, they can issue a identification that not only says they are a retired officer who meets the qualifications under LEOSA, but they can also annually certify their own retirees. Or so if an agency does that, that ID is supposed to be recognized throughout all of the United States for concealed carry. The other option is that they left it to the states to establish standards, but they never specified what agency is responsible for doing that. And that is why the Attorney General's office has been asking for the statutory clarification that the Department of the Attorney General will be that state agency that establishes that, to give clarity. To be clear, to be upfront, the Department of the Attorney General has been running the retired LEOSA firearm certification program for many years. And we do that with a memorandum of understanding with the police chiefs of the county, so that there is some, because normally firearm regulations are controlled by the counties. So that's why we have a memorandum of understanding, so that everybody's in agreement that the Department of Attorney General would be the person setting the standards. I hope that answers your question. If not,
well, I guess, do you know of cases in other states where, I'm not that familiar with this federal law. So is this federal law purposefully written to leave some ambiguity in terms of how the states implement? That is to say, if some states do not want to allow this practice, they can make that choice.
I do not know if it's what the federal government would or would not do if there isn't. There are other provisions that say that if the state does not establish the standard, then it'll be the standard for concealed carry in that state. But there's also provisions that require that it be the standard that a law enforcement officer must meet. So the Attorney General's office is basically trying to make sure that we do not get to the question that you're asking.
Have some states chosen to not allow this practice?
I do not know that. I cannot tell you that I know the answer to that one way or the other, but states that I'm aware of do in some form, because different, like I said, the agencies themselves.
Would you, okay, it would be good to know the answer to that question if anyone knows, but
Mr. Kitchens might have the answer to that.
Well, let me finish. If would you be concerned from the Attorney General's perspective if we chose to, not take action as a state and not allow this practice? Would we be in danger of being sued over it?
Whether or not we can be sued over it is not a question. I'm sorry, Representative, I do not know the answer as to whether or not we can or cannot be sued over that issue.
So it's not super clear cut. At least we can answer that.
Right, and part of it is that at this time the department is running a program that addresses the issue, so that it is not an issue that is being considered, I guess.
Okay, all right, thanks.
And other testifiers, we do appreciate your eagerness to contribute, but please wait until we call on you. Mr. Kitchens, did you have a response to or an answer to Rep. Lowen's question? Your sound is not coming through.
Sorry, currently with the research that I have done, actually, there's over 39 states that actually allow the LEOSA or have, basically standards that do allow it. The issue really that I have currently is the fact that out-of-state officers cannot come here and carry their LEOSA permit. There is an active program that you can get qualified through HPD, and you have to follow, of course, their certifications. You have to go to a company that they have described for the training, or they have established that will do the training for you, and you have to follow and qualify through them to be allowed to carry. But the problem really is that out-of-state people cannot for some reason. So I think I might have misunderstood the purpose of the bill a little bit, but I still think that we need to have the ability to do that. And if it means that we need to be,
Well, okay, but this isn't a chance to testify a second time.
Okay.
So it sounds like 11 states do not allow this practice. So it's not out of question to not allow it.
It's modifications of it. So in other words, there's certain additional restrictions that they require, that sort of thing. But it is one of those things that has come up in question. To answer your question, there are court cases and stuff that's happened.
Thank you. Rep. Ward, do you have a question?
Yes, thank you. Thank you, Chair. This is a question to the AG, and if she can answer it, Kitchens and Roberts. Speaking of the other states, what is the difference in the murder rate between concealed to carry states and those who do not have concealed carry?
When you say concealed carry states and those that don't, I'm sorry, Representative Ward.
Concealed, I thought concealed to carry was a rather common term where you can carry a weapon on your person in public or wherever you are.
What is, so?
In other words, the murder rate, how many, in other words, there are murder rates for cities, there are murder rates for state. What are the difference between those that have concealed to carry and those who don't have it? Maybe we should punt to Mr. Kitchens or Mr. Roberts on that.
Okay. Rep. Ward, who are you directing your question to?
Mr. Roberts or Mr. Kitchens? Oh, there.
Okay,
There's a
Mr.
distinct
Roberts,
study
he's got
that
his hand up.
this is part of the testimony that we need to get very clear on. Mr. Roberts, do you know the answer, or Mr. Kitchens?
So, to clarify, Director for Hawaii Firearms Coalition, we do all of the gun rights stuff here in Hawaii. That's what allows me to comment on these kind of events. There's no statistics between states that allow concealed carry and states that don't. I will point out that out of 50 states, Hawaii is the only state in the nation that does not issue concealed carry licenses. So that's why those stats are not available.
Thank you, Mr. Roberts. Maybe I'm going to be one of the witnesses here, because there's been clear NRA studies that show concealed carry states have less murder rates than those who do not allow it. That's the point, and this is a study of maybe 5 or 10 years ago. I'm not an expert on this, but that is a key individual, and I would ask the AG, if that's the case, should we not become a bit more safer by having this bill? Okay, that's rhetorical, unless you want to.
No, I was gonna. Okay, members, any other questions on this bill? All right, let's move on. It's gonna be a long, it's already a long hearing, I suppose. HB 2464, relating to the use of force in self-protection. First up, we've got Stolen Stuff Hawaii in support.
Sorry, yes, I do want to stand on my testimony, but I do want to provide some additional background to it. So running Stolen Stuff Hawaii, we have over 150,000 citizens of Hawaii or military members as a part of it. It's quite a large subsection. And the fact is that we encounter on the daily, a large amount of incidents where people are accosted, not only in their home and workplace, but on the street. I can cite several examples, not only recently, but in the past, where people have been assaulted walking to work, getting off the bus. It doesn't matter really where you are, as was stated earlier, that someone can be violent. And we have had a huge increase in mental health issues with the pandemic and the release of so many criminals to the streets, and releasing to the streets in new areas like Kapolei, now that Beretania is currently under renovation. We've got them in new areas, and people are constantly running into issues where they don't have the right to self-defense. They don't have the right. So currently, as the law exists,
you have to run the opposite direction if you're under threat. Now, imagine the idea of if you have your children with you, or you have something as you're in a very disadvantaged state when that happens. You know, you could the only direction could be running into traffic. So I think self-defense is very important. I'm very in support of this bill. It's a very minor change, and all it does is allow you to defend yourself, self-defense, not only in your home and workplace, but, well, anywhere you're at. So legal, like appropriate self-defense, not illegal, but appropriate. And that's my testimony. Thank you.
Okay, thank you. Next up, we have DC Project Hawaii in support. And just a reminder to everyone to please turn off your videos when you're not actively testifying.
Aloha, thank you again for the opportunity to testify today. I work full-time for a company that specializes in teaching legal and moral self-defense. We have analyzed upwards of 35,000 defensive encounters, and the overwhelming trend that we see is that when victims fight back, even when they're unarmed or untrained, any amount of resistance pretty much will oftentimes deter the attack and stop the attack. There's another portion of my testimony that I was going to share here, but Michael already touched on it about Stolen Stuff Hawaii, and how, you know, if you just scroll through the comments on any given day, you'll see just tons and tons of comments about how people are sick of being victimized and not able to defend themselves. And another thing that I wanted to touch on was that I think there seems to be a lot of misunderstanding that this bill seems to, it's like it's being equated with a pro-gun bill, and that it'll somehow increase violence, when actually nothing could be further from the truth. Actually, this is an anti-victim bill, and passing it would send the message to the people of Hawaii to let good, sane, sober, moral, prudent, law-abiding people to protect themselves, that they are worth protecting. Thank you.
Thank you. Next up, we have Everytown for Gun Safety in opposition.
Good evening, Mr. Vice Chair, Mr. Chairman. Thank you all for the time. My name is Samuel Levy. I'm Senior Counsel at Everytown for Gun Safety on behalf of our Moms Demand Action volunteers across Hawaii and our organization. I'm here to strongly oppose the adoption of HB 2464, a shoot first or stand your ground law for Hawaii. Contrary to what you just heard, this law is in fact a dramatic and dangerous distortion of the law of self-defense. It is a dramatic shift, and would mark a dramatic shift in state and common law approaches to how self-defense law works, what is justifiable and what is not. It would encourage a culture of violence, a culture of, vigilantism, and a culture of shooting first and asking questions later. There's no question that everyone across Hawaii and across the country is entitled to defend themselves and their families when the need arises. But what this bill does is turn the law of self-defense on its head. Hawaii law, like common law and so many state laws until recently, requires that the use of deadly force be limited to circumstances where it's absolutely necessary. That if there is an opportunity to safely disengage, to walk away before you have to take someone's life, that is a better option than killing them and claiming self-defense later. And what you have here in this bill is a bill that frankly would fly in the face of so many of Hawaii's strong gun safety laws that have been proven to save lives. These stand your ground, shoot first laws simply don't make anyone safer. They have been proven to in fact increase homicides, increase justifiable homicides. There's no evidence at all that they increase public safety. They also have dreadful impacts on communities of color and Black communities against whom they are used, with terribly disparate impacts across the states where they're currently in effect. So we stand in strong opposition to the bill. Our recommendation, frankly, would be that Hawaii take steps in the opposite direction, which is to make clear in your self-defense law, rather than this stand your ground approach, to address the kind of vigilantism and the kind of violence-seeking behavior that we saw in Kenosha with Kyle Rittenhouse and the Ahmaud Arbery murders, to actually make clear that people who instigate these kind of interactions cannot then rely on the self-defense law or the use of deadly force to commit murder. We stand in strong opposition to the bill, and I stand ready to take your questions. Thank you all for your time.
Thank you. Hawaii Firearms Coalition in support.
Aloha Judiciary Committee, Todd Yutake, Director with the Hawaii Firearms Coalition, and we oppose HB 2464. Basically, crime victims should have more rights and protections than criminals do. And it seems to be the opposite way now. People can be victims twice, once when they're attacked by a criminal, and twice if victims use deadly force to defend themselves and get charged with a crime. People can better defend themselves with a law like this. Basically, it provides them more defensive options, and they can focus on protecting themselves versus thinking about going to prison for doing something. And how does someone know if they can, under current law, how does someone know if they can be able to retreat safely? If you decide to run and they catch you, they got your back, you're screwed. 38 states have some sort of no duty to retreat, either through law or through the judiciary, and that number's growing, not being reduced. If this was a bad law, states would be repealing this. And just remember, a threat is still required. Nothing else has changed in the law except removing the duty to retreat safely if you're able to, or if you think you can. And a victim must still face a threat of serious bodily injury or death. This cannot be invoked for shoplifting, harassment, or getting the stink eye. So it has to be a serious bodily injury or death. And nor can it be used if the victim is the instigator or escalates the situation. So please let people defend themselves by supporting this bill. Mahalo.
Thank you. Next up, we have Moms Demand Action in opposition. Not present. Next up, Michael Rice in support.
Aloha. Todd pretty much covered what I was going to say. This doesn't really change anything except the duty to retreat. Now, if you are, because basically deadly force is only authorized under threat of rape or threat of murder. So, somebody just says, give me your wallet. Yes. I mean, it's that doesn't cover it. It's not just like somebody lurking about outside in the bushes, and you can go out with your gun and say, what are you doing, boy? Or whatever every town thinks we're talking about. And honestly, this isn't like deadly force. If I am confronted by somebody and in my motions of running away, I push them away from me and they fall, crack their head on the concrete, now it's murder from me defending myself while I was trying to flee. Yes, I fully support this bill. Please pass it. Thank you very much. I yield the rest of my time.
All right. Thank you. Andrew Roberts in support.
Good afternoon, Chair, Vice Chair. It's nice to be in front of you actually supporting a bill. I support this bill. It's just clarifying the language of Hawaii's current law. We heard opposition to the bill, and it seems that they don't understand what Hawaii's law says. They're only looking at this one part of it. Hawaii's law still requires distinct key factors before using deadly force, and that is the threat of death or serious bodily injury, rape, sodomy, or kidnapping of yourself or another person before force can be used. This is not like other states where if somebody pushes you or shoves you and just causes a mere injury that you can use deadly force. Serious bodily injury requires significant harm or significant risk of injury to internal organs or disfigurement. That would be something like using a knife or using a weapon. This is not a he said, she said, pushing and shoving match, and then you can shoot somebody. It's very, very distinct and very, very different. Hawaii still has those prerequisites before using deadly force. What this law does is it reduces that risk that you put yourself in where you have to make a decision on whether you can escape safely or not. For example, if somebody has a knife and you feel like you may be justified in using deadly force to stop them, but you can see that you could perhaps run 100 yards and get away, your brain now has to make the decision on whether you can outrun that person with the knife or whether you should use force to prevent yourself being injured. It just clarifies that a person shouldn't have to put themselves at further risk or make a determination when faced with those 4 prerequisites before using deadly force. It's not a stand your ground law. It's very, very distinct and different. Those laws have many more different steps than Hawaii's current law does. We support this bill fully, as do the people of Hawaii, and that's been clearly demonstrated by the overwhelming support and testimony. Thank you.
Thank you. Next up, we have Ryan Tinajero in support.
Representatives, thank you for your time. This time I stand in support of HB 2464 because it will remove undue restrictions placed upon constituents that prevent them from effectively defending their lives from an attacker. People in their homes, workplaces, or anywhere else for that matter, should not have to consider fleeing when their lives are put under attack. As it turns out, contrary to testimony presented earlier by Everytown, violence is already here. Passage of HB 2464 will not increase violence that is already ongoing and rampant throughout the states. As presented numerous times, the flight option isn't always viable. As it turns out, if you are injured or otherwise disabled, you literally cannot run away. A no vote to HB 2464 constitutes a no vote to the very preservation of your constituents' lives. Instead of voting no, I urge you to vote yes on HB 2464 in order to truly care for your constituents. I'm available for any questions or comments. Thank you for your time.
Okay, thank you. Next up, we have Mitchell Weber in support. Not present. Next up, we have Stephen Kumasaka in support. Not present. Next up, we have Marcus Tanaka in support.
Hello. So I was reading the testimony while this entire committee session was going on. It was pretty long. And I think there's a misunderstanding that, again, mentioned that this is like a firearms related bill or shoot and ask questions later. So one, nobody has been issued a concealed carry or open carry permit in the state of Hawaii in 20 years. This information is on our Attorney General's website. It goes back all the years and you can look at that. So to use the example, you can shoot someone outside of your house if you feel threatened. That means you'd be carrying a firearm illegally. So the other part of this bill states that, you usually cannot be the aggressor, so one, you can't carry a firearm anyway, either openly like Kyle Rittenhouse, you can't open carry in Hawaii anyway, or conceal carry, and you can't be the aggressor, which means if a person was trying to rob you and then you use self-defense, to fight back, and then the robber claims, oh, they're using self-defense in return, and you get injured, they can't do that because they were the initial aggressor. So that's all I wanted to input after reading the testimonies, and thank you.
Thank you. Next up, we have Amanda Ishida Norton in support. So not present. Okay, and that's all the testifiers we have here today. Members, any questions? Rep. Lopresti.
Thanks, Vice Chair. I have a question for Sam Levy with Everytown.
Yes, sir.
Thanks for your testimony. I want to start by saying I'm a co-signer of this bill, but I'm also somebody who's been supported by Everytown, Moms Against Moms Demanding Action, and I really value the work that you all do on a national level. But Hawaii is different, and one of the reasons I supported this, and I want to see if perhaps there's a misunderstanding from your testimony, is our bill, I think, is anti-aggressor. It is very clearly saying that if you are the aggressor, this does not give you a shoot first option. There's no shoot first legal option here anyway, because you can't carry a gun. We don't have the rates of gun violence that you have on the mainland. And it's not the case where it's a blue state where there's strong gun laws and you can just drive in from Georgia with a long gun. That's not something that's happening here. And so I just kind of wanted to know what your thoughts are on that.
Well, sure. And thank you for the question. With respect to, again, the rate of concealed carry of handguns is one thing, right? But they're not the only firearms that can hurt and kill people, right? Rifles and shotguns can be carried openly and can lead to devastating injuries and deaths. Then I'm familiar with the Hawaii law, right? The issue is, yes, you can only use deadly force in enumerated circumstances, but it's not. That's the apprehension of the person who believes they are under threat of one of those harms, right? It's not after the harm has befallen them. It's someone who can shoot first and then say, "Oh, I was really sure there was going to be serious bodily injury involved," right? That's an important distinction to make. And so too with the initial aggressor portion of your law, right? That the initial aggressor is not entitled to the law only if they initiated the interaction with the intent to seriously injure or kill the other party, right? That's a rather narrow exception in the scheme of things. So, the concern we have here is there's no one's questioning the right of people across Hawaii to defend themselves, right, from harm that might befall them, obviously, themselves and their families in reasonable ways. There's no duty to retreat in the home. That, of course, this is coming out in your bill, but that doesn't exist at all. So that was a misstatement. But again, what we're saying is if there is a way to avoid taking life, right? If there's a way to avoid killing someone and keep yourself safe in the process, that's all we're asking. And if there's not, then you are entitled to avail yourself of whatever means you need to if you reasonably believe that your life is immediately in danger. So it's unfair to call this a housekeeping change or a slight change. This is truly an inversion of self-defense law that has had disastrous consequences in other parts of the country that have adopted it since Florida started the trend. And I'm strongly happy to discuss with you further, but strongly urge you to reconsider.
I appreciate that because I've seen some of the data on how there actually has been an increase in violent death in places where laws like this were passed. But again, I think that those were places where you had the option of having firearms, and I don't think it is one here. I'll give you some personal examples. For example, like why I support this is I've had a knife pulled on me. I mentioned in a previous bill, my wife and I were nearly mugged right next to the police station. There was a murder at the next police station on the grounds of the police station, and we don't have enough cops here, frankly. And those are instances where I was able to extricate myself from that situation. People who are trained in self-defense, they know the best thing is to get out of the situation, and that's what I was able to do. But there's other situations where it's not something that's entirely feasible. I was at a park with my kids, and a group of guys started giving me, started threatening violence, and I had to retreat from that with my 8-year-old and my 12-year-old. And at some point, because I know I'm giving these examples because I know my constituents are going through these things if I'm going through them, and I'm an elected representative. And I think people need to have the ability and the confidence to know that they can stand up for themselves. And I just don't think it's going to be the same as the mainland, where there's been this increase in death. It's really just about allowing and enabling people to stand up for themselves.
Well,
it's not a question, but I am curious to your response.
Yeah, if I may, look, those situations are desperately scary, right? I live in, I'm speaking to you from New York now. I know what it's like. I was a prosecutor for a very long time before I came to Everytown. I know how horrific it is to be a victim of a violent crime. That's a very real thing, and no one's gainsaying those fears or those concerns, right? What I'm telling you is, in my estimation, the self-defense law that's codified in Hawaii gives you ample coverage. There's literally no impediments to using your right to defend yourselves, your family as the need arises, even with the use of deadly force in the circumstances where it's truly justified and where you can't safely avoid the confrontation. What you see, again, with well-intentioned bills and people who want to protect themselves or their communities are instead people who seek out these violent encounters and then shield themselves behind this kind of law, claiming that they thought they were in danger from someone who they murdered with a gun, who in fact posed them no threat, right? We're 2 years removed now from Ahmaud Arbery's death. Again, I hear you. It's not, no one's trying to come after the right to self-defense. It is codified there. It is widely available, and it is sufficient. This distorts that idea, we found with deadly consequences.
Thank you, Mr. Levy. And I certainly don't want to see this increasing some sort of vigilantism, but I appreciate your mana'o. Thank you. Thank you, Vice Chair.
Nakamura.
Just a question for the chair. Did we receive testimony from the public defenders, prosecutors, or attorney general for this bill?
sorry, did we receive testimony from the prosecutor, from the attorney generals?
I'm just curious. I did not see any testimony from the prosecutors or the public defenders or the attorney general on this particular bill. So I'm just asking whether they submitted late testimony.
Yeah, I don't see any from them.
Okay, thank you.
Rep. Tokioka?
Yeah, thank you, Vice Chair. Is HPD still on the Zoom? I know that they didn't submit testimony, but I do have a question for HPD if they're willing to answer it. Nobody? Okay. Maybe they're still on, maybe they're not, but I was myself surprised when I saw the signatories of this bill and I saw Rep. Lopresti sign the bill, and just to hear the testimony or his rationale made me happy to know that this is something that when I first read it, I was like, in fact, I would go back to say when we first passed the bill, that section I was like, if you're in your house and you have to retreat because somebody's coming into your house, that's kind of crazy if you ask me. And not to just say, anytime somebody comes in your house, you can shoot them, but if you're fearing for your life and all of the other stories we heard from people that testified. I'm sorry, is that HPD? Anyway, thank you, Vice Chair. I was hoping that HPD.
Yeah, I'm a little surprised HPD didn't submit testimony too, or AG's office. Members, any other questions for anyone who's here? It's getting a little late, so I'm not sure who's left.
Yeah, Chair.
Yep, Rep. Lopresti.
Especially since my name was brought up, is like, and I think it's worth saying this. It's not a question to anybody because AG's not here, the HPD's not here. I mean, what does that say? None of the law enforcement agencies are commenting or taking a position on this. That's really disappointing because we need their expertise and their knowledge to help make good laws, and they're not even being available to us for this, and that's a bit outrageous, frankly. But I just want to say, I'm a liberal progressive guy, but I support this because self-defense shouldn't be about left or right politics. It's not a Democrat or Republican thing, and it's just about safety. Thank you.
Okay, members, any other questions? Right, if not, we'll move on to HB 1471 relating to political parties. We have Office of Elections in support.
Good afternoon. The Office of Elections stands on its written testimony in support, and we'll be happy to answer any questions. Thank you.
Members, any questions? Report.
Thank you, Chair. Mr. Nago, it seems pretty innocuous, pretty benign, but why do you have to have the month and the day of the guy's birthday? Are people fudging their ages, or I notice you got to have the actual birth date of anybody who wants to be a political party? What's the logic of that?
So that's actually in the statute, a requirement that's in statute passed by the legislature. What this bill does is I don't think it touches that. It just makes the deadlines the same for submitting your rules and your officers.
The impression I have when I read it is, it already in statute requires, what year you were born, but it doesn't ask for the date of the month and the day of the month. Unless my understanding is incorrect. Why do you need to specify?
I believe report is correct. There is a section that says date and I think it's month and day. So
month and day versus,
I think it actually clarifies that you don't need the year now.
Correct. But I believe that might have already been in statute. This might be just clarifying that. Yeah. Yeah. This bill was just to make the deadline, the different deadlines the same.
So it's housekeeping and it's not prying or whatever, unprying. Thank you. Thank you.
Okay. Any other questions, members? If not, let's move on to HB 1823 HD1 relating to health. First up, we have Department of Health with comments.
Aloha, Vice Chair, Chair, and committee members. Lauren Kim from the Department of Health. I'll stand on the department's comments and will be available for questions. Thank you.
Okay, next up, Board of Nursing with comments.
Thank you. We'll stand on our written testimony.
Thank you. Stonewall Caucus in support. Okay, not present. HPH in support.
Hi, this is Michelle Cantillo. I am in support for Hawaii Pacific Health that we support this bill, and I'll be around for questions. Thank you.
Okay, thank you. Hawaii Center for Nursing with comments.
Aloha, this is Laura Reichart with the Hawaii State Center for Nursing. We stand on our written comments and are available for questions.
Okay, thank you. American Nurses Association of Hawaii in support. Not present. American Association of Professional Nurses in support. It's getting quite late, to be fair. Okay, not present. Compassion and Choices in support.
Hi, I'm Samantha Tradd. I'm with Compassion and Choices Hawaii. Thank you for hearing this bill. We stand on our written testimony, and I know a lot of doctors and other supporters have had to drop off, but we are here and available if you have any questions about the bill. Thank you.
Okay, thank you. Next up, we have Hawaii Society of Clinical Oncology in support.
Good afternoon, Chair and Vice Chair. My name is Dr. Charles Miller. I'm representing the Hawaii Society of Clinical Oncology, and I want to thank you for the opportunity to testify. I have been an active participant with medical aid in dying for the last 3 years since the law became active. And for the most part, the law is very successful. However, the amendments in HB 1823 are needed to correct some serious deficiencies. I've seen over 125 patients in the last 3 years, and unfortunately, 30% of them or more have died before they were able to obtain their prescriptions. Our waiting period is simply way too long. And the other point to address is the difficulty in obtaining access to medical aid in dying on the neighbor islands. It's very difficult. I think there's one practitioner on the Big Island, one or maybe two on Maui, and just a few of us here on Oahu. APRNs who are 100% fully trained and capable of providing medical aid in dying support to their patients should be allowed to do it. And I urge your support, strong support for this bill. And I'm available for questions if anyone has.
Thank you. Next up, we have the Hawaiian Islands Association for Marriage and Family Therapy in support.
Aloha, Chair, Vice Chair, members of the committee. My name is Becky Gardner on behalf of the Hawaiian Islands Association of Marriage and Family Therapy. We have comments related to the counseling provisions in this bill. Our understanding is with physician's assistants added, they can be counselors, but we're not sure that this language would ensure that they have adequate mental health training to be a counselor. Of the 5 core mental health professionals recognized by Department of Health and Human Services, all of them are included in the counseling provisions except for marriage and family therapists. So we respectfully ask that marriage and family therapists be added to these counseling provisions. And I would just add a personal note. I was the primary caretaker of my mother when she died of terminal cancer and was backup for my father when my grandmother was in hospice for the better part of a year. And the knowledge that marriage family therapists bring to this process in terms of family systems and family dynamics, I think are really important considerations in this very difficult decision. So thank you for the opportunity.
Good, thank you. Next up, we have Malachi Grange in support, individual.
Thank you very much. My name is Malachi Grange. Thank you, Chair, Co-Chair, Committee. I'm a retired registered nurse. I worked in Oregon where medical aid in dying started, and Hawaii providing end-of-life care. I'm currently a hospice volunteer. I totally endorse most of what I've heard. I I stand strongly in support, especially Dr. Miller. He brought it right out there. There are people, a lot of people, who are eligible for medical aid and dying, but can't make it because of the waiting times where they can't find a medical provider. I ask you briefly to take a look at this, take off your rep hat, your representative hat, and imagine your parent, your friend, someone you love, someone you support is eligible and is waiting to have these medications. In the meantime, they have set a time and a place for their loved ones to gather, a celebration of their life and the end of their life, a time for forgiveness and community, and last final acts of love. And it doesn't happen because they're waiting and they get sicker and they die. This is a tragedy and it doesn't need to happen. Please amend this bill. Thank you.
Okay, thank you. Next up, we have Aubrey Hoff in support.
Aloha committee. Thank you for hearing my testimony this evening. I'm testifying from Volcano Village in Puna District, rural Big Island, East Hawaii. I've been working to pass this bill initially. Over the last 10 years, I've been working on this issue for medical aid and dying in Hawaii. In the last couple of years, I have taken on a new role, and that is, unfortunately, as a patient navigator. I volunteer to do this work for people who are desperately seeking to use this law, but cannot find a provider. Unfortunately, that happens all too often, especially on the neighbor islands, or with people who are just too poor or not affiliated with a major healthcare organization like Kaiser or Hawaii Pacific Health. These people make their way to me when they've had nowhere else to turn. And just last week, I received a call from a Maui patient, a 60-year-old woman who has ovarian sarcoma, 3 to 6 months left to live. No one on her island will help her. I may be able to find someone to help her. This doctor may have to fly over from Oahu. Just this week, I received a call from the son of a patient in Waipahu. His dad has a neurological disease that's degenerative. He's very concerned because he's losing mental capacity, and they're not sure they're going to be able to make it through the waiting period. I urge you to pass this bill with these amendments that will allow these people to have the same access to the law as anyone else, no matter where they live, whether it's neighbor islands, Oahu, Honolulu, what have you. Thank you.
Thank you. Next up, we have Mary Steiner in support.
Hi, thank you very much. I've submitted my written testimony in which I stand in very strong support of this bill. This is an issue that has meant a lot to me for at least 10, 15, 20 years. And I really hope that today you folks will do the right thing and pass it and move it along. Mahalo.
Thank you. Next up, we have Charlotte Sharfin in support.
She's a physician who had to leave, unfortunately.
Yes, understandable. Next up, Brian Goodyear in support. Not present. Members, any questions? Okay, hearing none, we'll move on to HD.
Chair, sorry, Chair, I was off.
Go ahead.
Yes, to Dr. Miller, please. Dr. Miller, a question regarding, my understanding is 90% of the doctors opt out of doing medical aid in dying. What is some underlying reasons for that?
I'm sorry, your
breaking up
audio is a little garbled. Can you repeat, please?
My understanding is the majority, if not 80 to 90% of the doctors opt out of being part of medical aid in dying. And do you have some of the reasons for that? And it's important to know.
I think there's several, there may be many reasons. My biggest issue, I think, for physicians, especially for primary care physicians, is they are simply not aware of they don't want to get involved of having to do the complexities of meeting all the requirements of the law. And a lot of physicians are simply not comfortable with taking care of patients at end of life. Those are, I suspect, two reasons. Let me just qualify that. Most of the physicians like myself who are oncologists, who are pulmonologists, who deal with patients who have severe end of life cases, illnesses, they have come around significantly in the last 3 years since the law was enacted.
Thank you, Dr. Miller. I asked that question to really ask any of the Nurses Association. Have you done studies or surveys that suggest that there will be more participation or interest in this in the doctors? In other words, in terms of supply and demand, supply is very low on the physician level. Is the supply that high in the nurses level that this bill will actually be fulfilled with people who want to step up, or will it be like 10% or so of the nurses only want to engage? Is there any insight, again, about numbers? Is there any metrics that suggest this will work? Nurses Association.
Well,
sorry, Dr. Miller, this is for the nurses, unless you know studies, unless you have studies of the nurses surveyed.
I don't know of any specific studies. I can tell you, and I would ask Samantha Tread, there's plenty of support for nurses participating in medical aid in dying through policies for the American Nursing Association, several of the hospice nursing associations. So other than that, I don't have an answer.
Samantha, you can pick that up.
I have data on your doctor question. So a report recently came out from the University of Colorado on doctors who support patients in medical aid in dying and doctors who don't. Colorado also has an aid in dying law. And they found that the number one reason doctors don't support patients in it is because of the paperwork and the time it would take, because of the long, in Hawaii, it's a 17-step process. And actually this bill won't change the 17 steps. It will just reduce the waiting period and add more providers. I can tell you that we've talked to many nurses and nursing organizations over the last few years and have heard from many nurses who would be able to do this, who absolutely want to be able to support patients in this option. And if you look at the written testimony, there's written testimony there from nurses who would be able to do it, but I don't have data, specifically on this question.
So we don't know the participation rates, but you're saying they still got to go through all the 17 pages of hoops and other kinds of hurdles. Do the nurses do that, or do the doctors still have to do it even though they're not engaged?
So the 17 steps that's the process for the patient. A patient has to go through 17 steps to access the law. So they have to they actually have to be consulted with 4 different medical provider consultations. So 2 with the main medical provider who will end up writing the prescription, 1 with the second consulting medical provider, and then there's also a mandatory mental health assessment. And so this bill would allow all the medical providers who already have it within their scope of practice to be able to act as those medical providers. And then it would also help with the long waiting period so that patients don't have to suffer through the waiting period. But again, they still have 17 steps they have to go through.
So the nurses will step up and fill the gap. That's basically what you're saying, right?
Yeah, and I think, I'm hoping more physicians will also support patients. It's, we're also in a global pandemic and everybody is stretched thin right now. So I think being able to remove the barrier and thank you, Rep. Ward.
The last is more of a statement or rhetorical question of, do you guys know the John Ratcliffe, the poster child strategy for the waiting period? I think, Dr. Miller, I told you in the other hearing, it's basically order ahead of time. He had stuff at his bedside for 6 months ahead of time. I'm surprised you're not telling your patients that. They don't have to wait till this other, they just order it ahead of time, if the condition allows it. Anyways, that's the Radcliffe strategy, because I would see him for lunch and dinner for the last 16 months of his life.
I miss him too. And he was very supportive of this bill.
Thank you for saying that, Samantha. But that's the advice that he gave and that he showed by his behavior.
Good advice. I'd like to move on though. It's been going on.
Yes, sir. Thank you. Thank you, Vice Chair.
Okay.
6 o'clock news is on already.
Members, any other questions? Okay, hearing none, let's move on to HB 2148 HD1 relating to water pollution control for Substate Department of Health in support. Okay, assuming they're not here, Hawaii Reef and Ocean Coalition in support.
Oh,
Not here. Okay, Chuck, could you mute yourself and turn off your video? Thank you. All right, that's it. Members, no one's here to testify. So no questions. Next up, HB 2180 relating to harbors, Department of Transportation and support. If they're still here. All right, that's the only testifier and they're not here. So we'll move on to our last bill.
Chair,
Oh,
Chair,
go ahead.
David Rodriguez with the Department of Transportation, and we strongly support this bill. Thank you very much, Chair. Sorry for jumping in.
No problem. Members, any questions for Department of Transportation on this bill, 2180?
What bill is that?
Okay, hearing none, we'll move on to our last bill on the agenda, HB 2006 HD1 relating to permits. We have DLNR with comments.
Good evening, Chair, committee members, Michael Kane. On behalf of DLNR, we stand by our written comments. I would like to make one note that we can institute this as practice, regardless of the fate of this bill. We can start immediately should we issue permits for any sandbags in the future. And I stand by for questions. Thank you.
Okay, thank you, members. Any questions for DLNR?
Chair,
Report.
just a clarification, Michael, you're saying, hey, with or without the bill, you're going to do what needs to be done, and this is superfluous or what?
I possibly superfluous. This bill is tagged to what we call revocable permits. Most of the sandbag permits that we've issued, the authorized ones, are actually done under emergency authorization under Chapter 183C. So there aren't many that have reached where this law would take effect.
Okay, so you can live with or without it.
Correct. We could implement it. Well, we will implement it immediately. It's a good idea.
Okay. Thank you, Mr. Kane. Thank you, Chair.
Okay, thank you. Members, any other questions? Okay, let's recess for decision making.
at 2 o'clock in this room. So decision making tomorrow, 2 o'clock in this room. Okay, see if I- So Friday, February 25th at 2 p.m. in room 325. Okay, thank you very much, everybody. We are adjourned.
Thank you.